And then I don't know.
Right there, so it's like FaceTiming the judge or parole or whatnot. So you can let her know that you waive that, that changes anything. Hey, quick question for you. So he's saying that he waived it. I don't know if that makes any difference.
I never been through this, so I don't know what to do. I have no clue.
Chat with her, just see what she says.
So I don't have the paperwork that you did waive this, but we can do it on the record. We just have to wait until we go on the record, okay?
Oh, I don't know. I've never been through this. My first time, so I've never been through this. I don't know what's going on.
So she's just saying she doesn't have the documentation.
Okay, that's all right. It's all right.
And if you still wanna waive it, she's saying you can. She just needs it to be officially stated on the record.
On the record.
Meaning like
Yeah.
recorded. Okay.
Yep.
All right.
So just
I'm gonna
give me a moment, Mr. Rivera. We'll get started in just a second. I do need to record it, okay? So,
Okay.
Good morning. I am Parole Officer Trusello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Jose Rivera, inmate number 244121. Today is Monday, January 27, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and New Haven Correctional Center. Can you please state your full name and DOC inmate number for the record?
Jose O. Rivera, 244121, date of birth 8/16/79.
Oh, okay, thank you. So this is a public hearing. Public has access to this hearing, and the hearing is available via video live stream. So I have listened to what you were just saying, Mr. Rivera. You're requesting to waive this hearing?
I've never been through this, so I don't know what's the process. I've been home. I did 4 years in Osborn, 2 years out there. I did my I graduated from Workforce Islands. I did my next day program. At the end of the month, we'll start saying Rayfield with Glenn Young.
Yes.
So I don't really know
this is
what's the process.
what's going on. This is a preliminary hearing. So basically, we're establishing probable cause to determine whether or not you should proceed to a revocation hearing for your parole. So you do have rights at hearing. You did not request an attorney. Would you like to move forward with an attorney at this hearing? If you waive this hearing, what would happen is whenever your pending charge is complete in the courthouse, you would then be scheduled for a revocation hearing. Or we can move forward today, just you and I.
Because I got caught at third. And the third I got
So
caught.
again, this is 100% your decision, but those are the options. So we can move forward today, and I can determine whether or not probable cause is met with your violation. You can waive today's hearing on the record, and I'll just confirm if that's the way you want to go. Or we can continue the case for you to have an attorney for today's hearing.
What would you think I should do? Because it's my first time on parole. I've never been through this I have no clue. What should I do?
I mean, I can't give you legal advice, unfortunately. So waiving the hearing means that you're just conceding to the probable cause standard. So that means you're waiving a right to an attorney. You're waiving a right to respond to the violation notice. You're waiving your right to have today's hearing to establish probable cause. What that means is that once your case is disposed of in the courthouse, then you'll come back for a revocation hearing.
Okay.
So you are waiving a few rights if you waive today.
Yeah, so what's going to happen? What's going to happen?
So if you waive, you just wait until your case is disposed of in court, and then your parole officer in the community will let us know that it's done, you completed it, and that will bring you back in to do the revocation process.
Because I got 2 years to EOS, and I got 640-day jail credit.
Correct, but you also have pending charges. So those also have to be addressed in court. So if you wanted to move forward today, my advice to you would be that you are pending a court case. So you do have the right to remain silent during this hearing as well. But you do have the right to move forward with today's hearing if you want to go through the motion of it, or you have the right to waive it if you concede to the probable cause, and that will wait, we'll wait until your case is disposed of in court to bring you back in for the revocation.
Yeah. I
So
will do
did
my
you wanna
court
move
case
forward?
over. Because I wrote
Okay.
to waive the parole. I wrote like last week I wrote to waive the parole.
Okay. To waive the preliminary hearing?
Yeah.
Okay, so then I'm just gonna go over your rights with you, and just so you're aware of what you're waiving at this point, okay? So you are waiving the right to be represented by an attorney at this hearing. You're also waiving your right to receive the notice of the charges of violation. You're waiving the right to review the evidence against you before the hearing, and you're waiving the right to submit evidence in support of today's hearing. As we discussed, if you waive today's hearing, your case will just be pending with us until your court case is concluded. Once your court case is finished, we'll bring you back in to do the revocation process. Are you willing to still waive your right to today's hearing, Mr. Rivera?
Yes.
Okay, so I am now going off the record. This does conclude the preliminary hearing for Jose Rivera, inmate number 244121, as he has waived the right to his preliminary hearing, conceding to probable cause. And I am also finding the fact that there is probable cause and the acts are serious enough to warrant revocation. And as discussed with Mr. Rivera, his revocation hearing will be scheduled upon his conclusion of his pending court case. Okay, you're all set, Mr. Rivera. Thank you for talking to me today, and I'll see you soon. If you said your court hearing is in a week or two, hopefully it's concluded. The third, so next week, I think. So hopefully it's
because I told him
concluded.
I told him run my because I had 3 minutes, I told him run it together and get it out the way. I told him.
Yeah, so whatever happens, we'll be notified by Parole and Community Services, and then we'll bring you back in for the revocation hearing. Mr. Rivera, at that revocation hearing, are you interested in an attorney?
No, I got an attorney.
You have a private attorney?
Yeah, I got
So just
his name right here. Lord,
just
I
make sure
got
they file.
Lord Rubano, that's my lawyer.
Okay, make sure they file an appearance with us. Yeah, they have to file an appearance with Parole if you want them to represent you at your revocation hearing, okay?
All right.
All right, so
Okay.
you're all set, Mr. Vera. And like I said, we'll see you as soon as your officer sends us the conclusion of your court case, okay?
Okay, thank you for your time. I appreciate it.
No problem. You're all set. Have a good day.
Thank you.
No, thank you. Good morning, Officer Kwasnik. How are you?
Good morning. Good, you?
Good morning. Great. Mr. Plevka's attorney is in another hearing, so once they're concluded, he'll be popping over.
No problem.
Hello.
I'm here. I'm just listening.
All right, sounds good. Hello.
Thanks.
So for Plevka, we're still on standby?
Yeah, if you want him in the chair, he can sit in it, but yeah, I'm still waiting for his attorney.
Okay, well, I have him sitting right here. Whenever you guys are
Oh,
ready.
that's whatever. Okay, sounds good. I'll let you know
Whenever you're
as soon as he walks
I
in.
got you. All
Great,
right.
thank you.
You're welcome. If you want, I can do one of these. So like I'll rewrite the same information, you'll sign both, so you'll copy it. That way you know.
You got me charged. Say drop that, you're gonna release you back on the board. That's why they would put them on the machine. I want to say, okay. The one image, the one.
I do, no, some are there. That way you would say one.
So we're going that's the, I guess they're going to make them,
What was that?
it's a workforce.
Oh, okay. That's good though. Now you gotta go to the tech, that's why we're standing here.
I'll go to,
Yeah, okay.
I got some cards, I got you, but I'll go to, I got two more. So, no, we're missing great,
And let this be a stepping stone to get back out there and get right.
So, you know, arguing might be, didn't want to, you know.
Yeah, that's why then you don't want to. I get it, they go around. Okay, good luck with everything, right? Oh, here, that, right here, something like that.
Right, right. You're right. Keep off your car, you're ready for you.
Watched the game last night? Huh? Yeah, the ball game.
Good to see you. Officer, can you hear me?
Yeah.
Awesome. Perfect.
Good to go?
Thank you. Yeah, we're ready to go. Thank you.
Yes, ma'am. Right over here.
Officer Kwasnik, are you ready to proceed?
Yeah, I'm all set.
Perfect. So good morning, I'm Parole Officer Trusello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Erik Plevka, inmate number 314771. Today is Monday, January 27, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and New Haven Correctional Center. Can you please state your full name and DOC inmate number for the record?
Erik Ryan Plevka, 314771.
Thank you. This is a public hearing and public access to this hearing is available via video live stream. Present this morning is Attorney Famiglietti and Parole Officer Kwasnik. Attorney Famiglietti, can you identify yourself for the record, please?
Certainly. Good morning. Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, Mr. Plevka. Hello,
How you doing,
Fiona. Good. How are you?
I'm
Good morning, Fiona.
Good. Officer Kwasnik, can you please identify yourself for the record?
Sure. Dennis Kwasnik, Parole Officer 2, State of Connecticut.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to the appropriate sanction. The recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you see at this hearing can be used against you, and this hearing is being recorded. The testimony at today's hearing will be taken under oath. So Mr. Plevka and Officer Kwasnik, can you both please raise your right hands? You solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury.
I do.
I do.
Thank you. So we're going to go through the procedure for the hearing. The first is I'm going to read you your rights. Then we're going to review the parole violation charges that the state your parole officer is bringing against you. We'll then review and identify the exhibits filed for the record. The state will then have an opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering the evidence presented, I will announce my findings, and if I find you have violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history, and then once the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
So we're going to go over the rights that you have for this hearing. The first right is you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes, ma'am.
Great. You also have the right to review the evidence that has been brought against you before this hearing. You have the right to submit the evidence in support of your case, and you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
So we're now going to review the charges that the state, your parole officer, is bringing against you and the underlying information for each charge. So Officer Kwasnik, can you please read the charges that you have brought against Mr. Plevka?
Sure. Charge number 1, condition is obedience to the law. The violation details are on September 6, 2024 at 7:33 p.m. You were stopped by the Torrington Police for operating a motor vehicle with an upside-down license plate. During the traffic stop, it was determined that your driver's license was suspended. As a result of your actions, you were issued a summons for operating under suspension and failure to display plates. Charge number 2 is general no contact with the victim. Violation details are since December 8th, 2023, you have had contact with Amanda Schaeffer in violation of your strict no contact parole stipulation. Charge number 3 is no driving. Violation details are on September 6th, 2024. You were observed by the Torrington Police operating a motor vehicle. You did not have my permission to operate the motor vehicle.
Thank you. The state has also filed the following exhibits that have been marked for identification purposes. Officer Clausen, can you please identify the exhibits you've submitted?
Sure. All right. I have Exhibit A, signed special parole conditions. Exhibit B, remand to custody. Exhibit C, parole violation report. Exhibit D, notice of parole violation. Exhibit E, explore progress report. Exhibit F, emails from Community Solutions. Exhibit G, Torrington Police Report 24-29291. Exhibit H, DOC Security Division phone documents. Exhibit I, printout of judicial website of docket L18W MV24 0278239-S. That's it.
Thank you. But you also did submit an addendum on January 10th, 2025. Is that correct?
Yes.
Can you please read the addendum you submitted?
Yep. On January 9th, 2025, Mr. Plevka appeared at GA 18 under docket L18W MV24-0278239-S and pleaded guilty to 14-215A, legal operation of a motor vehicle while under suspension. Mr. Plevka was subsequently sentenced to 30 days in jail for his actions. The accompanying charge of failure to display number plates 14-18A subsection 1 was nollied. This time there are no pending criminal cases and his revocation can move forward.
Thank you. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified?
Yes, we have.
Great. I also did receive an exhibit from the defense as well. I have Exhibit 1, the list of parole accomplishments and future plans for parole reinstatement. Is that correct?
Yes.
Great. Do you need any additional time to submit other evidence?
No, we do not.
Okay, so today we do not have any witnesses. So at this time, it is the state's opportunity to call any witnesses, present evidence, and speak to any of the evidence submitted. Officer Kwasnik, would you like to make a statement?
Sure. Just to summarize why Mr. Plevka is in front of us today is basically his contact with his victim, which is his girlfriend. And if we could review his history, it started on January 19th, 2022, when the Winchester police responded to a domestic call involving the victim and Mr. Plevka. The victim reported that Mr. Plevka assaulted her in the car and they left the scene. Police stopped Mr. Plevka and observed the victim yelling for help inside the car. Upon further investigation, they discovered that Mr. Plevka punched the victim several times and thrown her head into the center console of the dashboard of the car. The victim was covered in blood and pleaded with the police to arrest Mr. Plevka. He was subsequently violated for those actions and was reinstated. When he was reinstated, he was also violated again 6 days after his parole was special parole was reinstated. He violated his parole conditions numerous times by contacting Schaeffer, going to her residence, violating his curfew, and failing to charge his GPS device. Misconducts were issued in an attempt to correct his behavior and to keep him into the community and try to control his behavior in the community. However,
Officer Kwasnik, anything, can you just focus on the charges brought today, and then that can be more for his history?
okay,
I
just
did
thought
read
it was
the
relevant because this is.
I read the PBR submitted, yeah, absolutely, but
okay, just to put on the record that this is the third violation of contact with the victim, and the history is violent in nature. So when he was reinstated for this violation on December 8th, 2023, A case management plan was developed to focus on his substance abuse and as well as his contact with the victim. Within a week of being reinstated, he had contact with his victim again. Investigation determined that Mr. Plevka had sent threatening messages to a male that was speaking with the girlfriend / victim, which resulted in criminal summons for harassment in the 2nd degree. Just want to make note that I issued a misconduct, kept him out into the community. Despite the aforementioned arrest for threatening, again, he was placed on GPS monitoring, and he was also told not to have contact with the victim. He said that he ended the relationship with the victim. I didn't have to worry about that anymore, and he would not have any contact. When he was pulled over for the license, driving without a license, I also kept him out in the community. However, when I discovered that he had contact still with the victim who was currently incarcerated at the time, a remand was filed. As the evidence will show, Mr. Plevka sent over 4,700 messages and over 1,300 phone calls to the victim. A sample of the evidence of the that you have, which I think are over 1,000 pages, clearly show just a cycle of violence, a pattern of violence. You'll have like a honeymoon phase where he's apologizing to the victim, and then all of a sudden he's threatening her, or he's claiming that she's having sexual relationships with other inmates and staff in the prison, and it's just a really volatile relationship. So that's why he was remanded, and really that's my main concern right now is his substance abuse and the contact with the victim based on his history.
Yeah. Counsel, it is now your opportunity to call any witnesses, present evidence, and speak to the charges.
He's not charged at all with any substance abuse issue, so that's relevant. But I've got no comment regarding the preponderance standard regarding any of these 3 charges. The first and the third are him driving when he shouldn't have been, and the second I'll address in my comments later.
Thank you.
But I've got no comment as to preponderance. There's clearly a contact.
Thank you. I do appreciate your comment. So I am just going to take a moment and I'll let you know my finding. So for charge number 1, I do find that you violated the condition of obedience to the law based on your conviction under Connecticut General Statute 14-215A, the illegal operation of a motor vehicle under suspension. And your conviction was on January 9th, 2025, when you were sentenced to 30 days in jail. In addition, the following evidence supports the charge. I have Exhibit A, C, G, and I. On charge number 2, I'm finding that you also violated the condition of a general no contact based on the evidence provided in support of the charge, which is Exhibit A, C, E, and F. And on charge number 3, the no driving, I am finding that you violated the condition based on the evidence provided in Exhibits A, C, G, and I. So that does conclude the fact-finding portion of the hearing. Before I make my recommendation, the state will have the opportunity to speak more to your background and history, and then after the state is finished, you and your attorney will have the same opportunity. So the purpose of this part of the revocation is to help determine what outcome I will recommend. So Officer Kwasnick, any additional information that has not already been submitted or stated?
Just going back to what I was initially stating, Mr. Plevka does have a history with the victim as my main concern. The prior 2 violations both involved violence with the victim. He has made statements to me that there's nothing that parole could say or that he'll do, that he's still going to have contact with the victim, that he loves her. I don't know how to control that behavior or to enforce that board's conditions with his attitude. My recommendation was due to this complex nature of his relationship with the victim, the ongoing risk that he poses with her, that, I mean, this really should be reviewed at a full panel. I don't feel comfortable making a recommendation for him to have contact or not. There's a history of abuse. I mean, the victim has reported to me, has reported to the police, a severe history of abuse by Plevka in the relationship. His messages to the victim while she was incarcerated show a clear pattern of a cycle of abuse or a battered women syndrome. In regards to his history, again, he has a history of domestic violence and non-compliance with parole. With the substance abuse, he admitted to me that he was abusing his Adderall that as a, I don't want to say an excuse for his behavior, but he was doing well with, as far as I know, with alcohol and drug abuse. So when we were focusing on the case management plan to address his behavior, he was doing a good job with the substance abuse besides the Adderall, which was legally prescribed, which I found out after the fact. With his toxic relationship, he said that he was married to the victim. In the evidence that he submitted, or the defense submitted, it says that they're not married. So there's no children. There's no, as far as I know, houses that they share or assets that they share. So this is not as complex as it could have been if they were married or share children. But again, with the toxic relationship, therapists see this. They've advised him against it. His parents are against it. The courts see it. I see it. We've had numerous conversations that this is just a toxic relationship. He's going to end up getting in trouble or relapsing if he has contact with the victim. So that high risk to of renewed conflict, the victim's history of substance abuse, too, her past violations of protective orders, their history together of excessive alcohol use. They were saying that they were drinking a gallon of vodka today or a day, and it would just result in violence between the two of them. He obviously has anger issues, which we have been addressing. Recent comments in therapy and emails also suggest he has an ongoing anger issues that still need to be resolved. Statements were made when I was remanding that he would have fought us in the past. He has fought us in the past when we were remanding him. And so, again, I think they should go to full panel. I'm uncomfortable making a recommendation of how long he should serve incarcerated, but if he is reinstated and he is allowed to have contact, I would recommend that he has mandatory participation in Explore. He was participating. He was doing a good job with that, and the R&R program for driving without a license, he was engaged with that. I would also like to see an anger management program stipulated. If the board places restrictions on contact with the victim, if it's conditional contact, again, I would feel more comfortable having the Explore program recommend that he have contact with the victim, and I think maybe mandatory couples counseling if contact is allowed, just due to this history, this toxic relationship they have, this history of domestic violence. And if no contact is stipulated by the parole board, if they want a strict no contact and they deem that their contact is too risky, I think I'd just place him on GPS and make a return of first sign upon contact with the victim just based on his past behavior.
Thank you. I do appreciate your statement. Counsel, is now your opportunity.
Yes. So I think the number 10 is there's a theme with the number 10 here. So my client and the alleged, I'm not going to call her the alleged victim, because the incident that the PREO referred to happened over 3 years ago. There haven't been any arrests or incidents between them that have called the police into call in 3 years. My client is 40 years of age. I spoke myself on the telephone with the alleged victim, AS, on the 17th and the 23rd of January. She absolutely wants contact with the defendant. Both my client and the victim, if we want to call her a victim, she's an adult. There are no protective orders. There are no restraining orders. There's just this order that they can't have contact. They've been together, here's the first 10, for 10 years. They're not married. She's not just his girlfriend, she's his fiancée. They intend to be together. This parole ends in 2027. So there's going to come a point in time when they're together. His parole wasn't violated. He wasn't remanded until September 27th. They had contact for 10 months and there had been no arrests. They had had contact for 10 months. The whole time. Yet he wasn't remanded until he was driving under suspension, and he served that time. So we have him driving when he shouldn't have driven and gotten arrested and done 30 days for operating under suspension, a nonviolent crime. And then just having contact. He's not charged with threat. He's not charged with breach of peace. He's not charged with violating a protective order. They both have been having contact. They both want contact. So it begs the question, should there even be a no contact order between the two of them? He did violate, but the result of violating a no contact order isn't to throw someone in jail. He's not on, he disposed of his case that put him on his parole 8 years ago. He had one case with her 3 years ago. My client obtained his GED online over the summer of 2024. That's commendable. He wants to, he was due to begin the auto mechanics program at Porter and Chester Institute. He had been tattooing out of his grandfather's residence. He worked part-time at Sasso's Coal Fire Pizza. In March to October of 21, he worked at ZT Construction. I think what's noteworthy is if he needs anger management treatment, even though there are no incidents here of any violence, and if he needs Explore, it is the most thorough domestic violence, anti-anger management, conflict resolution program we have. And I ask you to look at Exhibit E, which is the report from the Explore process report. 9-4 present participation fair. He has 2 fairs, but all of his other participations are good. 9-4, 24, 8-28, 8-21, 8-14, 8-7, 7-31, 7-17, 7-10, 7-3, 8. It just goes on, and I'll hand it to you so you can say you have it now. Participation, good. And only 3 unexcused absences in quite some time, from April to September. He was present 18 times. What more can we ask of him? He's doing the Explore program. He has a job. They're not married, but they have the paperwork to go and get married. I spoke with her. They just haven't been able to do it because she's incarcerated or he's incarcerated. These 2 people are going to be together. He's not charged with a crime related to her conduct. It's just a condition of parole, and he violated. But not every violation of a condition of parole requires someone to be warehoused in jail. Just because there's a protective order, there's no protective. But just because there's an order of parole and he violates it, doesn't mean, oh, we're going to throw him in jail now. Let's hold him in jail. He's been in jail. He's been in jail now since he was remanded on September 27th, excuse me. We don't have any allegations that he's contacted her since then. Maybe he got the message. So I don't think that incarcerating my client further when he has apparently gotten the message. We know she still wants to contact him. The second question, whenever we face a violation or a crime, when I was a public defender for 28 years in court, the first question is, has he violated? Is there a crime broken here? And if the answer is yes, the second question is, well, so what? So what? Just because you break the law doesn't mean you go to jail. Just because you violate a condition of your parole doesn't mean you have a long sanction. Thank you.
Thank you. Just gonna take a moment and I'll let you know my recommendation.
Take your findings.
I did.
I saw 3, right?
Yeah. Great, so I have listened to the testimony today and I reviewed the evidence provided. based on that, I am gonna recommend your parole be revoked and that you serve an approximate 7-month sanction period of confinement, and that's with a re-parole date of April 29th, 2025. In addition to that recommendation, I'm going to recommend the following conditions: no alcoholic beverage consumption, behavioral management program for domestic violence, no contact with the co-defendant Justin Lee Montaigne, general no contact with JD and AS, mental health treatment, and no operation of a motor vehicle without parole officer's permission. I do have a sponsor. Is that correct, counsel?
Yes, he wishes to be sponsored. One moment.
Ms.
His
Suma.
grandfather,
Yes.
Dennis
That's
Suma.
his, Mr. Suma? That's
Yeah.
his grandfather? Okay.
Thank you.
Okay, so happy house. So my recommendation is gonna go to the board on February 6th, 2025. And you'll receive a written notice, a final decision from them shortly after that date. At that hearing, the board can lessen my recommended sanction. They can let it stand, or they can impose the sanction longer than what I've recommended. If they do choose to impose a sanction longer, you'll be notified, Mr. Plevka, because they'll have a supplemental hearing and they'll want you to be present to address their concerns with them, okay?
Okay,
Do you have any questions at this time? Any questions?
no, I'm good.
Just briefly, Mr. Plevka,
Yeah.
if you have contact, they're going to violate your parole.
Yeah.
So if you wish to have contact with her, what you need to do is talk with your parole officer and go through the appropriate channels. You have no right to argue that you're in jail if by having contact. You understand that there's a clear no contact order, right?
Yes, sir.
You got to go about things the appropriate way. Okay?
Yeah.
They're trying to act in your best interest. That's their job. Okay?
I know. I understand.
This isn't a conversation or a debate. I'm just telling you,
I
as your
understand.
attorney, there's appropriate ways of going about things.
I know.
Okay.
All right.
So this does conclude the hearing for Erik Plevka, inmate number 314771. You're all set, Mr. Plevka.
Thank you very much, ma'am.
Have a good
Thank
day.
you,
Thank
Mr.
you, Officer
Pavlovich.
Klosnick.
All right, Eric, we'll see you in a couple months.
Yep.
All right, thanks.
Good morning, Officer Huff. Are you with us?
Morning, yes, I am.
Perfect. So I'm going to try to do Mr. Figueroa first with you, and hopefully it works out okay.
Okay.
Thank you.
Thank you.
is driving me up the wall. I'm stressed as fuck. My acne.
Good morning, how are you?
I'm well. How are you?
Great, thank you. I think I have two with you guys today. Does that sound right?
Is it Figueroa and Thomas?
Yes, if you don't mind, can you send Figueroa in first, please?
Not at all. Are you ready for them?
Yeah, I'm all set. Thank you.
I've had more therapists on my hands than I can count. I've been in and out of National since a little boy, ran to my dad's house. I've been in Yale New Haven Health LV2. I've been in Iowa Living. I've gone to the Joshua Center for an aftercare program. I've gone to Bradley School. I've gone to probably every school in the state. I've gone to ACES. I've gone to probably every special ed school conceivably possible in this state. And I've been either kicked out of everyone or I've moved from place to place and had to go to a different transportation.
Good morning, Mr. Figueroa. How are you?
1 second, let me get this out the way.
Oh, great, thank you.
Yeah, can you still see?
Yeah, that's perfect. Thank you. Good morning, I'm Parole Officer Trusell, and I'm a hearing examiner for the Board of Pardons and Paroles. And this is a preliminary hearing concerning George Figueroa, inmate number 192694. Today is Monday, January 27th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and McDougal Correctional Institution. Can you please state your full name and DOC inmate number for the record?
George Figueroa, 192694.
This is a public hearing and public access to this hearing is available via video live stream. Present this morning is Parole Officer Huff. Officer Huff, can you please identify yourself for the record?
I'm Parole Officer Huff, Hartford Special Management Unit.
Thank you. So before we get started, Mr. Figueroa, I do see you did request an attorney. Is that correct?
Yes,
I have not received an appearance for you. Have you spoken with anybody yet?
no,
I have not. Okay. Are you looking to obtain counsel for this hearing?
yes,
You are. So would you like a continuance of today's hearing for counsel for the Public Defender's Office to get in contact with you?
yeah, because I want to be able to,
You
yes,
want an attorney? Okay.
yes,
So just to confirm, I'm just going to repeat it one more time. Today's hearing is a preliminary hearing for George Figueroa, inmate number 192694. You are requesting counsel for this hearing and you would like a continuance to obtain representation, correct?
right,
Okay, so then I am going to continue today's hearing. I do have another one scheduled next week on the 4th. I think it's Tuesday. So I will schedule you for that hearing date and hopefully by then, the Public Defender's Office will be in touch with you, okay?
Would the public defender see me before that, before the
I'm
court?
hoping, did you submit an application yet?
Yes,
You did submit an application? Okay,
Yes.
so I'll have my supervisor maybe follow up with an email to them or I'll try to. That way, they can hopefully get in touch with you some point this week, okay?
okay,
All right, so this does conclude today's matter. As stated, we are going to continue the hearing to Tuesday, February 4th, 2025 for Mr. Figueroa to obtain counsel. Officer Huff, would you like to be present for that hearing?
Yes, please.
Okay, great. All right, so then we are all set. We are going off the record. Thank you, Mr. Figueroa.
Yep, thank you.
Have a good day.
Yes, thank you.
What do you mean by exclusionary zones? I thought.
Thank you.
Thank you.
Connecticut. So there might be more than just Woodford.
Finish.
So what if we're saying like I had to travel down I-95 to get to another location and it happened to come through that town line, would that be a violation of probation?
Again, I don't know if
Okay. I'm gonna be going from Bridgeport to Waterford where my grandma lives. So it's like, I want to know, so my grandma knows the proper route, so I'm not.
Thank you. Mr. Thomas, correct?
Yes, ma'am.
All right, I just need to locate your attorney and I'll be right with you, okay?
Okay.
Is there gonna be another follow-up meeting, or is this one of the last?
And it's gonna get assigned to appeal there. And once you get out, I bet then here.
All right, thank you.
I appreciate your time. I wish you a lot of luck there. We've got a lot of stuff. It's gonna take time. Just take it one day at a time. You know, another switch of PO. And just let them help you get this serious probation expensive. Whatever you need, or whatever you have issues and stuff. I tell everybody, especially this is your first time on probation. I tell everybody the same thing. I don't just look at the deal because you'll be able to get more assistance if you do that.
I appreciate it. Thank you. Have a good day.
Take care.
You as well. Morgan.
I can just keep kind of getting.
Like, he was shaking and sit around, what he's going, what the fuck is this?
I need to get out of here.
Sit around, man.
No, good. I actually had those.
Oh, don't get me like, more.
Oh, yeah.
We got Gail and Paroles.
They got you. They're showing it with
Wow.
me one more, give me that, like.
Okay, he should be on his way over, okay?
Yes, Kristen, thank you.
No problem.
Yeah.
But that's my workout.
These people are lying with that. Oh.
Not here. Just get room. I was just saying, not contact. This is supposed to. It's so low. Oh, yeah. I agree. Yeah, it's all. Oh, I know. I just try to make a little bit. Oh, yeah.
Okay, good morning. I'm Parole Officer Tricello. I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning Timothy Thomas, inmate number 405566. Today is Monday, January 27, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and McDougal Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Yes, my name's Timothy Thomas, inmate number 405566.
Thank you. This is a public hearing and public access to this hearing is available via video live stream. Present this morning is Attorney Sirica. Can you please identify yourself for the record?
Sure. Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit on behalf of Mr. Thomas.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked, and if I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath, so Mr. Thomas, can you please raise your right hand? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury.
I do.
Thank you. So we're going to go over the procedure for the hearing. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state or parole officer is bringing against you. I'll then review and identify the exhibits filed for the record. The state is not present at today's proceeding. However, you'll have an opportunity to present any relevant testimony and make any relevant testimony and any relevant documents. After considering all the evidence presented, I'll announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose and procedure before we begin?
No, ma'am.
Okay, so we're going to go over the rights that you have for today's hearing. The first is that you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive the written notice?
Yes, ma'am.
Great. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you also have the right to cross-examine any adverse witnesses. Do you understand all these rights, and are you ready to go forward?
Yes, ma'am.
So we are now going to review the charges that the state or parole officer is bringing against you and the information underlying each charge. So for charge number 1, condition of absconder, the charging officer reported that on October 29, 2024, you left Renaissance East, your only parole-approved residence, approximately 45 minutes after getting dropped off by the CTU van. You grabbed your property and ran out the front door of the halfway house. You have failed to make contact with the halfway house or your parole officer. Your whereabouts in the community are unknown at this time. On charge number 2, condition of travel, the charging officer reported that on 11/29/2024, you were apprehended in the state of Arizona by Phoenix Police and the Maricopa County Sheriff's Office. On 11/13/2024, you appeared in the Superior Court of Arizona, Maricopa County, and signed a waiver of extradition. You did not have permission to leave the state of Connecticut. Based on your actions, you're in violation of your release condition travel. The state has filed the following exhibits pre-marked for identification purposes as Exhibit A, the parole conditions, Exhibit B, the parole violation report, Exhibit C, the notice of parole violation, Exhibit D, the notice of parolee rights, Exhibit E, the remand to actual custody order, Exhibit F, the halfway house agreement, Exhibit G, the Renaissance East absconder report, 10/29/2024, Exhibit H, the pictures of Thomas absconding from the halfway house on 10/29/2024, 5 photos, Exhibit I, the Central Avenue absconder incident report, 3/12/24, and Exhibit J, the signed waiver of extradition. In addition, the state has filed the following addendum to the parole violation report on November 18, 2024, and that's also admitted into evidence and reads as followed. In reference to the parole violation report submitted by Parole Officer Babbage regarding Thomas Timothy, number 4055566, the following applies. On November 12, 2024, the Board of Pardons and Paroles issued a warrant based on the report declaring Thomas an absconder from parole supervision. On November 12, 2024, the case was deferred to DOC Parole Fugitive Investigation Unit for investigations and apprehension. And on November 12, 2024, a lead packet was sent to the Phoenix, Arizona Police Department and the Maricopa County Sheriff's Office requesting assistance with apprehending Thomas, who is at an urgent psychiatric center in Phoenix, Arizona. On November 12, 2024, Thomas was apprehended by the Phoenix, Arizona Police Department and is currently being held as a fugitive from justice at Maricopa County Jail, awaiting extradition to Connecticut. Please note this is Thomas's third time absconding from special parole supervision since he was discharged as special parole on 10/24/2023. Thomas was initially placed in the halfway house on 9/21/2023 and absconded on 10/27/2023. The BOPP approved a warrant for his re-imprisonment on 12/4/2023, and on 12/12/2024, Thomas was returned to custody. Thomas was re-released to special parole supervision on 3/12/2024, and a little over an hour later, he left the halfway house. The BOPP approved a warrant for his re-imprisonment on 4/15/2024. 4/23/24, Thomas was apprehended by NYPD. On 4/29/2024, he was extradited to Connecticut. For his current abscond, Thomas left the halfway house less than 45 minutes after placement on 10/29/2024, the day of his re-release to special parole supervision. On 11/12/2024, Thomas signed a waiver of extradition at the Superior Court of Arizona, Maricopa County on 11/27/2024. PO Carnegie, and Silva assumed custody of the absconder and extradited him back to Connecticut. The absconder was served his parole violation notice and parolee rights, while a remand to custody order was logged at HCC. Counsel, did you and your client receive the notice of parole violation, the parole violation reports, and all the other documents marked? Perfect. I did receive an exhibit from the defense. That's Exhibit 1, a list of parole accomplishments and plans, future plans for parole reinstatement. Is that correct, counsel?
Yes.
Do you need any more time to submit any additional evidence? So today we do not have any witnesses. So at this time, it is the defense's opportunity to call any witnesses, present evidence, and speak to the charges.
Yes, if I may just add regarding this, I did speak to my client, yes, on paper. This is a 45-minute in the community. My client lost his, not making an excuse for Mr. Thomas, but I just want to give you a little background as to what happened here. He lost his mother about 6 months ago. He just suffered from PTSD. When he left and went to Arizona, he did have a mental breakdown. He was not on medication at that time. He left here October 29th. I know the remand date on the paperwork shows 11/27, but it was actually November 12th. He went to the psychiatric unit in Arizona, and he's the one that called 911, knowing that he had left Connecticut. I know it says he was apprehended by the Arizona police, but my client did call 911. He was, and that's where they served the paperwork on him. So he was in Arizona from 11/12. He did voluntarily sign a waiver of extradition, but was not remanded back to Connecticut until November 27th. So the window seems longer, but he was in psychiatric unit on November 12th. Once again, I know this is bad. He was out for 45 minutes. I did speak to my client extensively via telephone. Since he's been in the facility, he is back on his medication. They have him being medication compliant. As I indicated, I on the travel, it appears like he ran into the Arizona, in Arizona by the Phoenix police. That's not the way. It's not worded correctly, in my opinion, okay? My client indicated he did call 911. He was in the unit there. They came. He knew by calling 911, his name was going to come up because of the warrant out of Connecticut. He did sign the paperwork to be brought back to Connecticut. And he is, as indicated to me and to my social worker, he is taking his medication in the facility, and they have him on the medication that he's supposed to be on.
Thank you.
You ever worked for a guy?
So I am, just take a moment. So I'm going to make a finding. So I do find that you violated the condition of absconder based on the evidence presented in Exhibit A, B, and G. And I'm also going to find that you violated the condition of travel based on the state's exhibits A, B, and J. So that does conclude the fact-finding portion of the hearing. Before I make your recommendation, you will have an opportunity to speak to your background history, any pertinent information. So the purpose of this part of the hearing is to help me make a recommendation. So counsel, would you like to make a statement?
Yes, my client is 49 years old. He does not have any children. He was at the Connecticut Renaissance, as I indicated, the reason why he went to Arizona. He did work last as an electrician. He did begin studying computer science and strength conditioning at Keene College in New Hampshire. He did, once he was incarcerated and once he was released from that psychiatric unit, he does meet with a counselor at the health unit at McDougal. And he is taking his Medicaid, he is compliant, I believe he's taking his Prexel. So he's back on track where he's supposed to be. As I told Mr. Thomas, when I first picked up this file, on paper, does not look good. But I know it was a short period of time. He did not go out and commit any crimes. He did end up in Arizona. That's where his family's from. And they said he lost his mother. He went to the unit, psych unit, did call 911 knowing there was a warrant for him. And when they came over, immediately signed the papers. Hopefully, when he's reinstated, he'd like to be placed in that halfway house in Waterbury, preferably Renaissance East. Interested in studying computer science, and he needs to apply for mental health disability. That's been an ongoing issue for my client, and he's obviously amenable to any treatment recommendation. I know I think it was Babbage recommended something in the 9-month range. I understand, with times he keeps absconding, that it's going to be an issue for him. But I just wanted to put on a record, give you a little background as to what happened here with Mr. Thomas. And I said he didn't, take off within 45 minutes, go out and commit a new crime. He ended up in a psychiatric hospital, which I think is important to know. Mr. Thomas, anything you want to add that I left out regarding your treatment and now that you're back on track? Unfortunately, in the facility.
I just want to say my attorney's right. It did say in the report that I was apprehended. I actually turned myself in. I called 911 and told a fugitive from Connecticut and that I needed help. And that's when I was placed in a mental health unit. And then the police came. Then they took me into custody there. So I do recognize I need help. I need mental health treatment. I'm having severe mental health issues, and I just need help. I need help with my mental health, and I don't know. I'm sorry that I've absconded a couple different times. I feel like I'm on the right track. I'm on my medication now, and I appreciate the leniency. Thank you.
I do have a question. Does that mean that you were not compliant with your medication last time you were released?
No, I wasn't even taking my meds at the time.
He was on that, but I already put that on. Yeah, after speaking to him, like I said, I picked up this file and I see 45 minutes. It's a problem for me too.
Yeah.
And I go through my questioning. He was not on it. He went to Arizona, but then he realized that something was going to happen. That's why he checked himself and into the psychiatric hospital. But ever since he's been into the facility, we confirmed that through my social worker. He is medication compliant.
Okay.
And he realizes he's got mental health. He's got to stay on his medication.
Absolutely.
And it can't be on and off situation. Thank you.
Thank you.
Thank you.
So I have listened to the testimony and I did review all the evidence submitted, and I am going to recommend your parole be revoked and that you serve an approximate 10-month period of confinement. So that's with the re-parole date of September 27, 2025. In addition, I'm recommending the following conditions: no alcoholic beverage consumption, behavioral management, program for anger management, a general no contact with JB, mental health evaluation, and halfway house placement in Waterbury. My recommendation is going to go to the board on February 6, 2025, and you'll receive a written decision following that date. At that hearing, the board can lessen my recommendation. They can let it stand, or they can impose a sanction longer than what I've recommended. If they do decide to impose a sanction longer than what I've recommended, a supplemental hearing will be held and will be notified, but you'll be present for it to answer their concerns and questions, okay?
Yeah, so what's the date of release? What's the date?
September 27.
9/27.
And what, can I be credited for the 2 weeks that I was held in custody in Arizona? Does that count towards?
Well, no, that's my final decision. I'm doing 10 months from the day you were brought back to Connecticut, okay?
So it's the 22nd of September, you said?
9/27.
9/27. The board will make the final decision on February 6th, and you'll receive it in the mail, the written decision from them, okay?
Okay.
All right, good luck to you.
You're all set, Mr. Thomas.
All right, thank you. Good day.
This concludes the final revocation for Timothy Thomas, inmate number 4055566. Good morning. How are you?
Good. He's I'm giving him a call now. He should be ready, but I'll get him on his down here as soon as possible.
Perfect. Thank you.
Yep.
Yeah. Okay,
Good luck.
thank you, thank you.
Good morning, Mr. Ortiz. How are you?
I'm doing good, how about you?
Good. So we can't start until exactly 10:30, so we have about 4 minutes, okay? So just hang there. We'll get right to you soon, okay?
No problem.
All right, thanks.
You're welcome.
Good morning. I'm Parole Officer Trusello, and I'm a hearing examiner at the Board of Pardons and Paroles. This is a revocation hearing concerning Jaciel Ortiz, inmate number 3834441. Today is Monday, January 27, 2025. And this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Cybulski Correctional Institution. Please state your full name and DOC inmate number for the record.
Jaciel Ortiz, 3834441.
This is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Sirica. Attorney Sirica, can you please identify yourself for the record?
Sure. Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit, on behalf of Mr. Ortiz.
Thank you. This is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked, and if I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Ortiz, can you please raise your right hand? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning the case shall be the truth, the whole truth, or not, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes, sir. Yes, miss.
Sir.
No, just me, just sir. Oh, no.
He did say miss out. He did say miss out.
You can put your hand down, Mr. Ortiz.
Okay, sorry about
Thank
that.
you.
I'm nervous.
That's okay. Me too. I keep stuttering, so we're good. So, we're going to go over the procedure for the hearing. First, I'm going to
Okay.
read you your rights. Then I'm going to review the parole violation charges that the state, your parole officer, is bringing against you. I'll then review and identify exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background history. Do you have any questions about the purpose or procedure before we begin?
No.
Okay, so we're going to go over the rights that you have for this hearing. The first is you have the right to be represented by an attorney and counsels here present for you. You have the right to receive the written notice of charges of violation. Did you receive that written notice?
He did.
Yes, miss.
Okay, so you also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call any witnesses, and you have the right to examine any, cross-examine any adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, miss.
So we're now going to review the charges that the state, your parole officer, is bringing against you and the underlying information for each charge. So on charge number 1, condition of reporting, the charging officer reported that on 10/3/24 and 10/8/24, you failed to report in person to the New Haven Parole Office as instructed. You were aware of the dates and times, but failed to report. On 7/13/24, you left your residence between the hours of 9 p.m. I'm sorry, I missed one. No, that was reporting. Okay, now we're on charge 2, GPS. So the underlying information is on 7/13/24. You've left your residence between the hours of 9 p.m. and 6 a.m. You're in violation of your GPS agreement. On 9/19/24, 9/25/24, 10/1/24, and 10/5/24, you allowed your GPS unit to shut down due to failure of charging the unit. You again were in violation of your GPS agreement. On 10/3/24 and 10/4/24, you left your parole approved residence between the hours of 9 p.m. and 10 p.m. Again, you're in violation of your GPS agreement. On 10/8/24, you removed the GPS unit from your body without the consent from parole. As a result, you're in violation of your GPS agreement. Charge number 3, condition of program participation. On 9/5/24, you, upon discharge from the App Foundation, you were instructed to participate in individual outpatient treatment at the App Foundation clinic. You failed to attend and participate in your mandated substance abuse programs as instructed. On charge number 4, condition of obedience to law, on 10/11/24, you had police contact with the West Haven PD. You operated a motor vehicle in a reckless manner, causing parole and the West Haven Police Department to pursue you. As a result, you received the following new charges. 53A-167A, interfering with an officer resisting, 14-299, traffic control signals, 14-224B3, evading responsibility, injury, property damage, 14-36A, operate a motor vehicle without a license, 39A-371, failure to insure private motor vehicle, and 14-12A, failure to renew registration. You were scheduled to appear before the Milford GA22 court on 11/5/24. And charge number 5, condition of drugs, on 7/16/24 and 8/1/24, you rendered a urine sample for instant toxicology drug test. Both samples rendered positive for an illegal drug. You did not have medical authorization to possess, control, or use the substance/drug. The state has also filed the following exhibits that have been pre-marked for identification purposes. I have Exhibit A, the conditions of parole, Exhibit B, the remand to actual custody, Exhibit C, the parole violation notice / rights, Exhibit D, West Haven PD police report, Exhibit E, parole violation report, Exhibit F, misconduct, Exhibit G, the app transition plan, Exhibit H, the GPS agreement, Exhibit I, the GPS allied universal reports, Exhibit J, the judicial branch pending case detail, Exhibit K, the release of information, Exhibit L, the images of CT IDs for proposed sponsors, Exhibit M, the summons, Exhibit N, toxicology screening, biotech labs, Exhibit O, voluntary admission, and Exhibit P, text messages. In addition, the state has filed an addendum to the parole violation report on January 7th, 2025, and that's also admitted into evidence and reads as follows. On 10/11/24, Mr. Ortiz was arrested and charged with 53A-162, interfering with police officer, 14-299, disobeying a traffic signal, 14-224, evading responsibility, 14-36A, operating without a license, 14-12A, operating without proper registration, and 38A-371, operating without insurance. On 12/7, okay, we're good, doing good. 12/27/24, Mr. Ortiz appeared before the Milford Superior Court for the following charges on companion dockets: A22M MV24-0080877S and A22M-CR24-0126543S. Docket number A22M-MV24-0080877S were combined with docket number A22M-CR24-0126543S. Mr. Ortiz was sentenced and found guilty on the following three charges: 53A-162, interfering with police officers, 14-224, evading responsibility, and 38A-371, operating without insurance. He received 30 days jail with each charge to run concurrently. The remaining charges were marked nolly. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents?
Yes.
Great. I have received defense exhibits. I received a few. Let's grab it. All right, so I have Exhibit 1, a list of parole accomplishments and future plans for parole and statement. Exhibit 2, the certificate recognition for living in balance Tier 2 drug and alcohol program. Exhibit 3, the offender accountability plan revision form. And Exhibit 4, the domestic violence program offender participation evaluation form. Is that accurate, counsel?
Yes.
Great. Do you need any more time to submit any additional evidence?
Yes.
Okay, so today we do not have any witnesses, so it is your time now to call any witnesses, present evidence, and to the charges.
Yes, if I may. Regarding charge number 1, Mr. Ortiz, do you recall parole officer indicated October 3rd, 2024 and October 8th of 2024? Why you didn't go in person to the New Haven parole office?
Because I got COVID.
Okay. You tested positive for COVID, and did you let your parole officer know?
Yeah, I sent a test with a paper for the paper they give me in the hospital, in jail hospital, and
Okay.
she said, okay, no problem. I send you the day you about to come see me back, and she never sent me. She never sent me the date.
Do you remember when the COVID was when you tested positive?
I think it's like the same day I sent the paper, like 2 days before that. The day she told me, oh, go. I send the paper. And I said, yo, I have COVID. I cannot go see you. And she said, no problem. I'm gonna reschedule you the day you can see me.
Under charge number 2 on the GPS, it looks like on July 13th of 2024 is approximately about an hour. Do you recall where you went for that hour?
I told her, she called me on Monday. She said, come see me in my office. And I told her, miss, I forgot, I had to go pick up my wife. Nobody, I got the car that time because I'm working in Tougher Tire. And I'm not supposed to go that time, and I pick him up. I take only 20 minutes short. It's like 20, 25 minutes She see me wanna go all the way pick up her and come back to the house. I don't go nowhere. She got all those when I go to the hotel and come back. It's not like I go do something crazy or I go to the club or something like that. No, I go pick him up at the same time, like 12:20. When I come back, it's like 12:20. And she told me come to the office and she said, I'm violated. And
So you picked up your wife was working at a hotel, correct?
in the hotel, yeah, she worked in the hotel right there and handed it. And I told the location, everything. I told him, I'm not lying to you. I pick him up. I'm not supposed to go nowhere that time because I know that's my mistake. But I got the car for that time, and that's why I pick him up. It's only like 20.
Hold on a second. Chaz, you told your parole officer where you went, and obviously it showed the time frame, and she was able to look at your GPS points there. So what you told her, she was able to verify, correct?
She verified right there, and she said, okay, she don't care because I'm not supposed to go nowhere. That's what she told me.
Which is true. You didn't have a curfew, but the GPS points showed what you told her. She was able to verify with the GPS.
She verified. She verified, but she said she don't care. Like she because I'm making that's my fault. She said, okay.
And October 8th, where you removed the GPS, you knew on October 8th you were going back to jail already, correct?
She told me she about the human time off program. And I'm stressed because my mother, she live in Providence. I don't see my mother almost 7 years already. And they told me she got cancer. And I want to see her. I got almost 5 months with the bracelet. And I told them, listen, can you call my bracelet? And she don't want to call it. She don't want to take that out for me. And that time, I got a lot of stress. I started using drugs. And my mind is not 100%. And I called the bracelet. She called me the same day they called me. She said, Ortiz, I'm about to pick you in your house. I'm about to put you in timeout program. Because you cost your bracelet, I'm about to put you in timeout program. 45-day timeout program. But that time, I scared. I see mad police coming. And that's all I ran. I'm right there in the car waiting for my sponsor to pick me up. And when I see all the police, I'm scared and I left. And that's what they pursued. But when they stop me, I don't put nobody in danger. I put my hands up and go to jail. Like it's not like I started to go crazy and I stop it. I said, you know what, let me stop it.
On charge number 3, I just want to clarify the program participation. You did, if I'm reading this correctly, you did successfully complete the APT Foundation. It was 30 days inpatient, correct?
Yeah, I did it 28 days in our foundation.
28 days, okay.
28 days. 28 days, our foundation. I graduated. They give me certificate, everything. And she know because she had to give me the permission to get out from that program. She had to go and pick me up and say, Ortiz, you good.
All right, so the issue was with the follow-up part of it. Is that correct?
With the follow, I have to go. She want me to go voluntary 1 time a week. Okay. But I'm working at top retired. I'm working 8 in the morning to 5 o'clock at night. And the appointment's supposed to be in the morning at 11 o'clock. And my job, she don't want me to do because I did already 30 days in the program. And she want me to do it and they don't want to wait for that. It's Ortiz. I cannot give it all days.
I just want to clarify this. This is on 9-5. The language here used upon discharge. It was a successful discharge, correct? 28 days. Okay. 28 days, yeah. I finished. Right. I finished the program. Okay. I just wanted to give you a little background as to what happened here. So that's it for the first part of the hearing. That was charge number 5, that he self-admitted is an issue with the substance abuse. So I'm going to talk about what he's done at the second part of the hearing since he's been there. Thank you.
Thank you. So I'm just going to take a moment. I'll let you know my findings.
Okay. And then when I'm here, I did it.
Yeah, hold on. That's the second part. Hold on. You're jumping ahead. We're going to get to that. I promise you we're going to get to that.
Sorry about that. Sorry.
Okay.
I do want to hear it, but I'm just going to announce my findings first, and then we'll move on to that, okay? So, charge window number 1, I am going to find that you violated the condition of reporting based on the evidence in Exhibits A, E, and P. On charge number 2, I find you violated the condition of GPS based on the evidence provided in Exhibits A, E, F, H, and I. And on charge number 3, I'm finding that you violated the condition of program participation based on the evidence provided in Exhibits A, E, and G. And on charge number 4, I found you violated the condition of obedience to the law based on your conviction of interfering with an officer and evading responsibility and operating without insurance when you received a sentence of 30 days jail, with each charge to run concurrently. In addition, the following evidence supports the charge is A, G, E, J, and M. And lastly, on charge number 5, I found that you violated the condition of drugs based on the evidence provided in support of the charge, which is exhibits A, E, F, N, and O. So that does conclude the fact find portion. This is, before I make my recommendation, you'll now have the opportunity to speak to your background history, any information that you feel is pertinent. So counsel, would you like to make a
Yeah,
statement?
may I just make one comment? I know you made your findings. I just want to put on a record. In Exhibit P, my client did send over a document, text to his parole officer from Yale New Haven Hospital regarding the positive COVID test. It looks like it was sent at 5:11 p.m. And his response was, "Don't text me outside of business hours." That's Monday through Friday from 8 a.m. to 4 p.m. This one, so at Exhibit P, yeah, it's like the 3rd page in. I just want, he did send it in. I'm not disputing your finding, but I just want to show you that my client did make an effort to send in the COVID test from Yale, and then that was the response to that. Okay, I'm not disputing your finding, but he did make an attempt, just so you know. He wasn't saying that just to say that. He did send it over to his parole officer, yeah. Okay,
Yep.
thank you. Yeah, I just wanted, yeah.
All right, before you start, let me just write it down. You're thinking I wanted to review it. All right, counsel, would you like to make a
Yes,
statement?
on behalf of Mr. Ortiz, my client is 35 years old. He does have one 15-year-old son who lives in Florida. He did pay child support while he was out. He does have contact with his son on a regular basis. Upon his previous release, he did have a sponsor. He also has indicated through that he did successfully complete, I want to make sure that's clear, the App Foundation. It was 28-day inpatient program. The issue was with the follow-up while he was working at Town Fair Tire. But like I said, I'm not questioning what the parole officer, it just says upon discharge. And I just want to make sure it's clear that he did successfully complete that 28-day inpatient program. Upon his previous release, he was in Project More in New Haven. And then looks like in 2023, also did some residential services at the App Foundation. He did also have some services at the Connections Halfway House. While in the program, he did have a case manager, Ms. Atkins. While he's been incarcerated in Robinson, he did obtain his certification. He enjoys culinary arts. Also previously started a barber program in New Haven. He has about 3 weeks left to finish that program. As he indicated through his testimony, his most recent job was employed full-time at Town Fair Tire in Orange. He'd been there on and off for the past 4 years. Also, while he was out, he worked full-time as a chef at a bakery in New Haven. He was there until he was remanded. As I indicated, a job at Town Fair Tire. As far as treatment, he did do an intake in Midwestern Council for Alcoholism, CCA, in New Haven. He was not recommended to engage in treatment services, but he did do the intake. He did start while he was out the domestic violence classes in New Haven. And since he's been remanded at this particular time, he's employed as a chairman as block. Just successfully complete the Tier 2 program on just recent January 9th of 2025. That was Exhibit 2. And he did successfully complete domestic violence. That's Exhibit 3 and 4. So he has been taking his time since he's been incarcerated seriously, he's been engaging in programs. I did indicate a sponsor, it's a family friend. It's Pepperlin. I provided you with the address and a phone number. He does want to get his barber license. He's indicated to us he's able to return to town fair tire. He's been at that job for 4 years on and off. They're also interested in applying at Chipotle Mexican Grill in Brantford, and he's amenable to any treatment recommendations. I said he did complete inpatient, but he needs to get going with the follow up on that. So, Ortiz, anything you want to add about your background of the treatment for when hopefully you're reinstated?
And they give me yesterday. I finished. They give me on Friday. I finished voices too.
Okay.
You know, pero I did the voices, but they give it to me late, and it's a Friday, and I finished, and they give me the certificate for tier 2 right here. I already got it, and the domestic class, the DV class I finished, the study session I finished too. I got all of them right here, and they give me certificate. You know, this time, you know, I know every time I fuck him on the street, but this time I know I got a problem and drugs, and I. You know, I did it the best I can, you know, and I want to keep going, doing good, because all of the problem I have is drugs, and that's what I did the voices. I did a tier 2, and now I go to NA meetings every Mondays, Wednesdays, and Friday. I go, and I want to, you know, when I'm here, for the time I'm here, the almost 4 months. You know, I try to do the best so I can change my life, because if I don't change my life, nobody do it for me. And I want to, you know, do the best. I want to get out of here and see my mother before she died, because, you know, they told her she don't got. I don't see from. I don't want to see it. I don't want to make a phone call and tell me my mother died. I want to see her, you know, because it's bad, and I don't want to do that. I want to do the right thing, you know. I want to do the right thing. That's why I don't want to.
All right. Thank you.
Thank you, Mr. Ortiz.
Thank you.
I'm just gonna take a moment and then I'll let you know my findings. I mean, my recommendation.
Thank you.
Okay, so I have listened to the testimony today. I've reviewed the evidence submitted, and based on all of that, I am going to recommend your parole be revoked and that you serve a 5-month period of confinement. That's with a re-parole date of March 11, 2025. In addition to that recommendation, I'm going to recommend the following conditions. Behavioral management program for domestic violence, no contact with your victim AS, a general no contact with Liberty Bank at 171 Silas Dean Highway in Wethersfield, Connecticut, a general no contact with CC or CR, a mental health evaluation, and then I'm going to put the sponsor in. Mr. Ortiz, should I put in the halfway house placement for a backup plan, or is it?
Yeah, I got to show the house already got. I called the guys, everything already, you know, he know the money, he got the money already to hold in the bed for me in New Haven. And the sponsor not going through, I want to recommend the sober house, because I got the guy who got the bed, he from New Haven. And
So you don't want to go to Miss Camper?
No, I want to go right there. I want to go
there
there
first.
And they don't go through for my address, I want to go to sober house, you know, it's better for me too.
So what you're
Thank
telling me is you have no interest in the halfway house, correct?
No interest, because halfway house is not good for me.
Okay.
Like, you know.
All
Thank
right,
you.
so then,
I appreciate it.
yep, I hope I have the sponsor. So my recommendation is going to be going to the board on February 6th, 2025. You'll
Thank you.
receive a written notice after that hearing date. At that hearing, the board can lessen my recommended sanction. They can let it stand, or they can impose a sanction longer than what I've recommended. If that
Okay.
does happen, you'll be notified, because there'll be a supplemental hearing that you'll be present for to address their concerns, okay?
Thank you, miss.
All right,
Jackson, my day, what's my day?
Well, I'm recommending March 11th.
March 11th,
Yeah. You call our office. If you call our office on Friday, February 7th, just speak to one of my secretaries. I won't be here. Just ask if the board approved the recommendation. That way you'll know that you get
Thank
out
you.
March 11th. All right, good luck to
Thank
you.
you.
Good luck.
Thank
Keep
you.
doing
Thank
good
you for
things in
everything.
there. Keep going to those meetings, okay, Mr. Ortiz?
Thank you. Yeah,
All
thank
right,
you.
good luck.
Thank you.
Concludes the revocation hearing for Jostiel Ortiz, inmate number 383441.
You guys all set? All set?
We're all set, thank you.
You're welcome. Have a good day.
Too. That room up there. Okay. She comes out. I hope they answer.
Taylor? You can have a seat. Bring the vote down here.
All right, thank you.
Good morning, Mr. Taylor. How are you?
Hi, yourself?
Good. So we're going to get started. So I'm Parole Officer Tricello, and I'm a hearing examiner at the Board of Pardons and Paroles. This is a revocation hearing concerning Douglas Taylor, inmate number 187390. Today is Monday, January 27th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Bridgeport Correctional Center. Can you please say your full name and DOC entry number for the record?
Douglas Taylor, 187390.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Dean. Attorney Dean, can you please identify yourself for the record?
Yes, Hannah Dean on behalf of Mr. Taylor. Good morning, sir.
Good morning.
This is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked, and if I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Taylor, can you please raise your right hand? You solemnly swear, solemnly, sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes, I do.
Thank you. So we're going to go over the procedure for the hearing today. First is I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. Then going to review and identify exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
So we're going to go over your rights for this hearing. So for your first rights, you have the right to be represented by an attorney at this hearing, and you have counsel here present for you. You also have the right to receive written notice of the charges of violation. Did you receive that written notice?
Yes.
You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. You understand these rights, and are you ready to go forward?
Yes.
So we're now going to review the charges that the state or parole officer is bringing against you and the information underlying each charge. So on charge number 1, condition of absconder, the charging officer reported that on 10/16/24, you left the Isaiah halfway house without authorization. You have no further contact with Isaiah's staff or this officer. You left your only parole-approved address without program completion or permission and became unaccountable in the community. Subsequently, your whereabouts in the community were unknown. And on charge number 2, condition of halfway house placement, the charging officer reported that on 10/16/24, you left your only special parole-approved residence, the Isaiah halfway house, without authorization and didn't return. You failed to contact your parole officer or halfway house staff, and you failed to return to the program. Your whereabouts are unknown at this time. Also, your actions violated your signed halfway house agreement, specifically the clause which reads, "I will not leave the physical confinements of the halfway house unless authorized by program staff or parole. I will only go to the locations indicated on the approved community paths unless changes have been authorized by staff." The state has also filed the following exhibits that have been pre-marked for identification purposes as Exhibit A, the remand actual custody order, Exhibit B, the parole violation report, Exhibit C, the notice of parole violation, Exhibit D, the notice of parolee rights, Exhibit E, the signed PCS conditions, Exhibit F, the signed halfway house agreement, and Exhibit G, the Isaiah halfway house incident report. In addition, the state has filed an addendum to the parole violation report, and they submitted it on November 21st, 2024. That is also admitted into evidence, and it reads as follows. In reference to the parole violation report submitted by Parole Officer Elger regarding Taylor Douglas number 187390, the following applies. On November 15, 2024, the Board of Pardons and Paroles issued a warrant based on the report declaring Taylor an absconder from parole supervision. On November 18, 2024, the case was deferred to DOC Parole Fugitive Investigations Unit for investigation and apprehension. On November 21st, 2024, Taylor was apprehended in the Bridgeport Park by this FIU Officer Silva, along with Bridgeport District Office officers. Taylor was admitted to Bridgeport Correctional Center, where a remand actual custody order was lodged without incident. Taylor was served his notice of parole violation as well as his notice of parolee rights on the same day. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the documents that have been identified?
Yes.
Great. In addition, I have received an exhibit from the defense, which is Exhibit 1, the list of parole accomplishments and future plans for parole reinstatement. Is that accurate, counsel?
Yes.
Do you need any additional time to submit other evidence?
No, thank you.
So today we do not have any witnesses. So at this time, it is the defense's opportunity to call any witnesses, present evidence, and speak to the charges.
Yes, as to both the charges, I just have some like general comments. From speaking with my client and understanding his perspective on what happened, it is, I believe, an unfortunate situation. My client had been doing well in the community for several months, but unfortunately was having some difficulties while in the halfway house. He reports that while he was there, many of his personal items, including money, credit cards, things of that nature, were going missing left and right. And when he did address this with staff, he unfortunately was not given assistance to prevent this from happening again. So he, I believe, felt as though himself and his personal items were not safe in that environment. So those are my comments as to the charges. At the appropriate time, I would like to remark on his background and future plans.
Okay, thank you. I'm just going to take a moment. I'll let you know my findings. So on charge number 1, Mr. Taylor, I am going to find that you violated the condition of absconder based on the evidence that has been provided in exhibits B and E. And on charge number 2, I'm also going to find that you violated the condition of halfway house placement based on the evidence provided in exhibits B, E, F, and G. So that does conclude the fact-finding portion of the hearing. Before I make my recommendation, you and your counsel have opportunity to speak to your background, history, and make any relevant comments. Counsel, would you like to make a statement?
Sure, thank you. My client, Mr. Taylor, is 49 years old, born and raised in the Bridgeport, Connecticut area. His primary support in the community is his wife, Ms. Taylor, who he has been together with for 24 years. He has one child who's 19 years old, and then he also assisted Ms. Taylor in raising her children as well. Most recently, while on special parole beginning in March 2022, Mr. Taylor was placed at Isaiah Halfway House in Bridgeport. Previously, he utilized Renaissance Maple Street Halfway House from March 2021 until June 2021. He does have a high school diploma, GED, that he received in the 90s. In 2013, he graduated and obtained a culinary degree while at the Radegowski Correctional Facility. That was an 18-month program he completed. While at the Maple Street Halfway House, he was working at American Fabrication, making furniture, and then he was also part-time at Hartley and Parker in Stamford, was there for about 2 months, and then he was at the furniture making business for about 1 year until he got laid off. From May until June 2021, he was doing men's cognitive behavioral therapy at Connecticut Renaissance in Bridgeport. He also reports that he was working with J Brothers program and did complete that, and was also working with New Visions Ministries in Bridgeport. Specifically, there was someone there named Elder Mack who he was working with and got his Ocean 10 while he was there as well to further his education. He has custody insurance. He does have some medical issues, including diabetes, asthma, high blood pressure. Since he's been at Osborn, he's been on the list for employment. Upon reinstatement, he would love to be sponsored by his wife. If possible, I did speak with her, Ms. Lashika Taylor. In the alternative, he's open to a halfway house in the Bridgeport community due to the proximity of his support network and his employment opportunities there. He's interested in going back to school, perhaps a trade school to help further his career. He's open to all sort of employment opportunities. He's eager to get home and care for his wife. She does need to get hip surgery. He's her primary help in the community, so he's really wanting to get back to help her. He also feels that he could benefit from some ongoing psychotherapy, perhaps CBT. So he's looking to get into some sort of treatment for that when he gets out. And then he's also looking forward to getting back with his medical providers and getting back on the right regimen of medications. He's been incarcerated for a little over 2 months. I would ask that he be given the soonest possible reparole date. His special parole ends, I believe, in 2026. And so I know that he really wants the support of parole so he can get reinstated, get back on his feet, get a job, get to treatment with their support. So I know he is hoping to get out as soon as possible. I also can note from speaking with his wife, I do believe that she will be a very positive support for him. I think that he had done a lot of good things while in the community before to try and get himself back on his feet. So I would just ask for the soonest date so he can get back out. Thank you.
Thank you. What do you have his wife's?
Her name is Lashika Taylor. I should have a phone number for her.
No address?
Do you have the address for your wife's home?
Yes.
Okay.
It's in 141, it's in Ansonia.
I need the full address so I can put it in the system.
149 Howard Avenue, Ansonia, Connecticut.
Thank you.
And that is your first choice?
Yes.
The sponsor? Okay, all right, and then I'll grab the phone number.
Yes, I should have that somewhere in here. If I don't have it down here, I have it upstairs.
All right, just give me a minute and I'll let you know my recommendation. So I have listened to the testimony today. I've reviewed all the evidence submitted. And based on that, I am going to recommend your parole be revoked, Mr. Taylor. I'm going to recommend a 7-month period of confinement, which is a re-parole date of, just confirm, December, January, February, March, April, May, June 21st, 2025. In addition to that date and recommendation, I'm going to recommend the following conditions: no contact with the victim TS and LT without your parole officer's permission, and a mental health evaluation. And we're going with sponsors, so I will not do the halfway house.
Is the if I may just inquire, the LT, is that I know you can't say the full name on the record. I just want to make sure that's not his wife.
Oh, it is.
They still have that on there. I would just I understand that you're stating your findings. I would just argue that I believe that she was on there from an incident that happened years and years ago, where I don't believe there were any charges that stuck. I think that they may have been involved in alleged domestic incident. However, I think all charges related to that were not laid. So I don't think there, and I can confirm as well that there's no active protective orders or anything like that.
Okay, so I do have to keep that on. What I'll do is I'll still put her in as a proposed sponsor. It's up to Parole and Community Services on where they want to place you, but then I am going to just recommend the halfway house as well.
Okay.
Because it is up to them. I can't make the decision. But yes, that is it. So I'm going to keep that on for now just because it's there. The board can do what they need to do. Also, so yeah, so my recommendation is going to go to the board on February 6th, 2025, and you'll receive written notice about the decision shortly after that date. At that hearing, the board can lessen my recommended sanction. They can let it stand, or they can impose a sanction longer than what I've recommended. If they do choose to go with a sanction longer than what I've recommended, a supplemental hearing will be held and you'll be notified because you'll be present for that hearing to address their issues, concerns, any questions they have for you, okay? So that is all for today. Mr. Taylor, do you have any questions?
No.
So this does conclude the final revocation for Mr. Douglas Taylor, inmate number 187390. You are all set, Mr. Taylor.
Thank you. And sir, if you want to call my office on the 6th, we can let you know what the board decided, okay?
All right,
Thank you. If you have any questions as well, feel free to call.
all right.
Uh-oh, I can't see it yet. Hi, good morning.
Good morning. If we can start with Mr. Brayman, that'd be great.
Freeman, okay, they're not here yet. I just wanted to ask you, I was just about to email you and let you know about Lazada. He's in the flu dorm. Is it something that can be rescheduled or does he need to be here? If so, we can have him last when everyone's out.
I mean,
I don't want to reschedule it.
yeah, no, he can come.
He can come down?
last. Yeah, that'd be
Okay, I'll
great.
do him last for you. And I'm just
Okay.
waiting for the other guys to get escorted down.
Okay, perfect. Thank you.
You're welcome. Thank you. I'll put you on mute for now.
Okay, thanks.
Thank you.
Right here?
Yep, you can have a seat.
Hi, Mr. Raymond.
Yes, ma'am. How you doing?
Great. I'm Officer Trisella. We can't start for 3 minutes. Unfortunately, we have to wait till exactly 11:30. Okay, so we'll be right
Okay.
with you. All right.
Yeah.
Hey, good morning. I'm Parole Officer Trisella. I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning Clay Bremen, inmate number 419670. Today is Monday, January 27th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Osborn Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Yes, it's Clay Michael Brayman. My inmate number is 419670.
Thank you. This is a public hearing and public access to this hearing is available via video live stream. Present this morning is Attorney Dean. Attorney Dean, can you please identify yourself for the record?
Yes, Hannah Dean on behalf of Clay Brayman. Good morning.
Good morning.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not that allegation is true. Excuse me. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. A recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Brayman, can you please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury?
Yes, ma'am.
Thank you. So we're gonna go over the procedure for your hearing now. The first is I'm gonna read you your rights, then we're gonna review the parole violation charges that the state, your parole officer is bringing against you, and then I'm gonna review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings, however, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I'll announce my findings, and if I find that you have violated one or more of the conditions of your parole, you'll have opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
So we're going to go over the rights you have for this hearing, and the first is that you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes, ma'am.
So you also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. You understand these rights, and are you ready to go forward?
Yes, ma'am, I understand.
Perfect. So we are now going to review the charges that the state your parole officer is bringing against you and the underlying information for each charge. So on charge number 1, condition of absconder, the charging officer reported that on 1/6/21 you left Fellowship House, your only parole approved residence, without permission or program completion. Your whereabouts in the community are unknown, and you have failed to make contact with halfway house staff or your parole officer. And on charge number 2, condition of travel, the charging officer reported that on 11/7/2024 you appeared in the Fulton County, Kentucky District Court and signed a waiver of extradition. You're being held as a fugitive from justice after being apprehended by Hickman County Police. You did not have permission to leave the state of Connecticut, and based on your actions, you are in violation of your release condition travel. And on charge number 3, condition of halfway house placement, the charging officer reported that on January 6, 2021, you left Fellowship House, your only parole approved residence, without permission or program completion. Your whereabouts in the community are unknown, and you have failed to make contact with halfway house staff or your parole officer. The state has filed the following exhibits that have been marked for identification purposes. They are marked as Exhibit A, parole conditions, Exhibit B, the parole violation report, Exhibit C, the notice of parole violation, Exhibit D, the remand to actual custody order, Exhibit E, the halfway house agreement, Exhibit F, the Fellowship House absconder incident report, Exhibit G, the text conversation between Bremen and P.O. Babbage, 13 pages, Exhibit H, the signed waiver of extradition, and they have also submitted a Fellowship House consent and acceptance that I'm identifying as Exhibit I. In addition, the state filed an addendum to the parole violation report on November 1st, 2024, that is also admitted into evidence and reads as follows. In reference to the parole violation report submitted by P.O. Babbage regarding Bremen Clay number 419670, the following applies. On February 11, 2021, the Board of Parole issued a warrant based on the report declaring the offender an absconder from parole supervision. On February 17, 2021, the case was transferred to the parole officer and to wait for investigations. On 10/22/2024, a lead package was sent to Hickman, Kentucky PD, where Mr. Bremen was located and taken into custody. A copy of the warrant and the remand was supplied to both Hickman Police Department and the Fulton County Detention Center, where Mr. Bremen is currently being held. On November 7, 2024, Bremen signed a waiver of extradition at the Fulton County District Court. Bremen was extradited back to Connecticut on December 20, 2024, and Bremen was returned to Hartford Correctional Center, where remand to custody was lodged as approved by P.S. Waldron. On the same day of December 20th, 2024, Bremen signed the notice of violation and parole rights and was provided with copies. So did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified?
We received everything except for that Exhibit I, the Fellowship House consent and acceptance.
I think it was part of the Fellowship absconder report. I separated into two just because of the consent.
So that would be Exhibit F.
It looks like, or maybe here.
Let's see.
Maybe I assume
the halfway house agreement.
Yeah.
Let's see. Okay, yeah, I see the second. Thank you so much.
No problem.
Yes, we've received everything.
Okay, great. Okay, so I also did receive an exhibit from the defense, and that's Exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Is that accurate, counsel?
Yes, thank you.
Do you need any time to provide additional evidence?
No, we don't, thank you.
Okay, so at this time, we do not have any witnesses, so it is the defense's opportunity to call in witnesses, present evidence, and speak to the charges and the evidence submitted.
Yeah, thank you. So I just have some global comments about the different charges. So my client was cooperative with extradition back to Connecticut to handle this parole violation. He's been in the community since December 2020, has picked up many cases during that approximately 4-year period. He also reports that he's been sober for the duration of that time and is finally getting his life together. He's built a support system, has been working, got, I believe, a long-term partner, and has a very supportive network now. I mean, we both know that people, places, and things are typically the biggest triggers to relapse, which Mr. Bremen has struggled with in the past. But I think it's worth noting that he has remained clean and crime-free in the community for a substantial period of time. And I think that is due in large part to the support system he's built for himself. And then at the appropriate time, I would just like to make comments about his background and future. Thank you.
Thank you. So I'm just gonna take a moment, I'll let you know my findings. So for charge number 1, condition of absconder, I do find that you violated that condition based on the evidence provided in Exhibit A, B, and F. For charge number 2, condition of travel, I also found you violated that condition based on support of the evidence that supports the charge, which is Exhibit A, B, and H. And on charge number 3, I found that you violated the condition of halfway house placement based on the evidence provided in State's Exhibits B, F, and I. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation, you will have an opportunity to speak to Mr. Bremen's background, history, violation, anything that's pertinent for the case. So counsel, would you like to make a statement?
Yes, thank you. Mr. Bremen's 30 years old, born in Westerly, Rhode Island, raised in Pawcatuck, Connecticut. He has a strong support system, which consists of his 2 grandmothers and a grandfather who all live in New York, his significant other, Miss Stewart, and her father, who both live in Kentucky. He also has 3 children, ages 10, 8, and 3, who reside in Tennessee. They were the driving force that made him move after ending the relationship with his child's mother. He did relocate to Kentucky so that he could still be close to his children. Most recently, upon release to discretionary parole, after he successfully completed the timeout program in December 2020, he was placed at Fellowship Halfway House in Groton. He graduated from Stonington High School in Kentucky. He reports that he was landscaping full-time with a friend for about the past 3 years. Beginning in December 2020, while at Fellowship House, was doing medication-assisted treatment, methadone, and was doing individual therapy as well at Root Center in New London. In Kentucky, my client reports that he was helping neighbors with yard work when they were in need. He was doing medication-assisted treatment in the form of methadone and will begin participating in weekly methadone groups while incarcerated. During all incarcerations that Mr. Bremen has had, he's never once had a disciplinary report. So I would argue that he is a really model inmate in that regard. Upon reinstatement of special parole, he's open to being placed in a halfway house, either in Hartford, New London, or Waterbury. He would like to return to the life he created in Kentucky eventually, and would like to be sponsored by his partner's father, Mr. Stewart, in Hickman, Kentucky. He also wants to further his education. He's open to enrolling in tractor training school to get his CDLB. He also is open to any sort of job opportunities and all treatment recommendations, and also wants to keep doing the methadone program and participate in individual therapy. His EOS date per the DOC is later this year in June. I'm just asking that he be released prior to that date so that he can establish some services in the community with paroles assistance. This is in a situation where there's new criminal charges, and I think he was doing very good while he was out. So I would just argue that he should be given an opportunity to establish services with the help of parole. Thank you.
I do have a question. Did you mention that he was participating in the MAT program in Kentucky as well?
Were you doing, I'm not sure if he was doing it while in Kentucky. Were you doing medication interest?
I wasn't able to because the closest clinic they had was about 3 hours away, and I wouldn't be able to, commute every day for 3 hours back and forth because of job and whatnot. So.
Okay.
Yeah.
So you were just clean on your own out there? No programs or anything? Were you participating in anything?
Yes, ma'am.
Thank you. I'll just give me a moment. I'll let you know my recommendation. So I have listened to the testimony today. I've also reviewed all the evidence provided. Based on that, I am going to recommend that your parole be revoked and that you serve an approximate 6-month and 8-day period of confinement as a sanction, which is a no new re-parole date, as your current end of sentence is June 28th, 2025. In the event that the board decides to lessen my recommendation, I will recommend the following conditions. No contact with your co-defendant, Donald Jarris. No contact with the victims, AW, CH, LK, and JS. A general no contact with CB, a mental health evaluation, and a halfway house placement in Hartford. So that is my recommendation. It's going to be forwarded to the board on February 6th. And you will receive a written decision shortly after that date. At that hearing, the board can only lessen my recommendation or they can let it stand. So you'll be just notified of their decision after that date, what they chose to do, okay? Do you have any questions right now, Mr. Brayman?
No, ma'am.
If you have any questions, feel free to call my office and I can discuss whatever you need with you, okay?
All right.
This does conclude the final revocation for Clay Brayman, inmate number 419670. All right, you're all set, Mr. Brayman. Good luck, sir.
Thank you.
Okay. Hi, are you
How you
Mr.
doing?
Holman?
Yes, I am.
Mr. Holman, it's always a pleasure to see you. How are you doing?
I'm doing okay. Just hanging in there. And yourself?
This is Mr. Holman.
Okay.
Yeah, he's not represented at this time. Thank you. So Mr. Holman, I am Officer Trusello. I'm the hearing examiner at the Board of Pardons and Paroles. And this is your preliminary hearing. No attorney, no appeal. Okay. So this is your preliminary hearing and it's concerning Jonathan Holman, inmate number 367233. Today is Monday, January 27, 2025. And this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Osborn Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Yes, Jonathan Holman, 367233.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. So Mr. Holman, I just want to talk to you quickly. I know you did request an attorney. Is that correct?
Yes, I have an attorney for this case, but I don't know if my attorney can be for this hearing.
A private attorney, correct?
Yes.
So they can be. They just have to file an appearance with us. Have you talked to them at all?
It's all new, so it's like I didn't even know this was going to happen today. And then I don't know if he know either. So
okay. Would you like me to continue the case for you to speak with him and have him represent you here, or what is your plan?
Yes.
Or would you like to move forward without representation?
Can he be here today, or we'll have to start a new hearing?
You said, can he be here today?
Yeah, or we'll have to start a new hearing.
I'd have to continue you to a later date. Ideally, I can put you on my next hearing, but that's next Tuesday, and sometimes that's not enough time. I don't know who he is, what his schedule is, so it might be best, like, if we do that, we could continue it one more time again if we need to, if you would like him here. It's completely your right. So those are two options today. We can continue the case so you can speak with him. He has to file an appearance with our office, so tell him to get in contact with us, or we can move forward today without counsel present to represent you.
I think I can move forward.
You're gonna move forward? Okay.
I think I'll move forward.
So there's gonna come a few times, I'll ask you maybe once or twice more before you can stop this to get representation, okay? Because once findings are announced, any of that, it's done for today, okay? But as long as you're sure, we can keep moving forward right now. Is that still okay?
Yes, I'm sure.
Okay, Mr. Holman. So I'm going to go over the purpose of today's hearing. It is a preliminary hearing and it has three purposes under Connecticut law.
Okay.
The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Holman, can you please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
So we're going to go over your procedure for today's hearing. So first, I am going to read you all of your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. I'm then going to review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, yes, I do have a question. Okay, I have a co-defendant for this case.
Mr. Holman, but I also want you to be aware your pending charges. I do not want you to incriminate yourself, because anything you say today can be used against you in any courthouse across the state, okay? So just be mindful of what you want to say and what's needed to be said, okay?
Okay.
Do you still want to ask your question?
Yes, please. 'Cause I just want. I think it's detrimental to the hearing.
Okay.
As far as my co-defendant, he cleared my name with my parole officer, which was kind of a little too late because I already was violated. But now I have him sworn to my lawyer to write a statement on himself to clear my name.
Okay, so that's still pending though, correct?
Yes.
Okay.
Because he was supposed to do it today. I'm not sure if he did it already.
Okay.
So my lawyer can have it notarized and hand it to you guys and the prosecutor.
Okay. So yeah, so that, I mean, that can be submitted to us whenever needed. At this point, we are just here to see if more likely than not something happens. So that's what probable cause is, as I'm going to review the charges, the evidence submitted. I'm going to make the finding as to yes or no and tell you what happens. Because the outcome of this could be that you'll be released, or it could be staying in jail pending your revocation. There's a lot of options to this. So I'm going to go over this one more time with you. You do have the right to be represented by an attorney at this hearing. You may hire your own attorney. It sounds like you have one. And it is your right to have them here. Are you looking to have them represent you for this preliminary hearing?
I feel like I need him.
You do not feel like you need them? Sorry, I couldn't hear you. You do not feel like you need them?
Yeah, I don't feel like I need him here.
Okay, that's okay. I just want to make sure. And again, I'm just going to be annoying with it. You have the right to remain silent. You're pending charges, so just be mindful, okay?
Okay.
So just to confirm for the third time, I'll do it 3 more times. You are really okay to move
Thank
forward.
you, I appreciate it.
You're okay to move forward right now without your legal representation?
Yes, I am.
Okay, all right. So then you also have the right to receive written notice of the charges of your violation. Did you receive that written notice?
Yes, today I did, actually.
Okay, were you able to review it?
Yes.
Okay. You also have the right to review the evidence against you. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine any witnesses. Do you understand all of these rights, and are you ready to move forward?
Yes.
Okay, so I'm going to review the charges that the state, your parole officer is bringing against you and the underlying information for each charge. So it is just the one charge, and it's for charge number 1, condition of obedience to the law. The charging officer reported that on January 9th, 2025, you were served an outstanding arrest warrant by Shelton Police. According to the arrest warrant issued by the court honor about 10/2/2024, you were charged with larceny 2nd degree and conspiracy to commit larceny in the 2nd degree. Charges stem from you possessing and attempting to cash stolen lottery tickets. On January 10th, 2025, you were arraigned in Derby Superior Court and with a return to court on February 20th, 2025. Just so you know, in regards to this charge, a judge of the Superior Court of the state of Connecticut has already determined that there's probable cause to believe that you committed the act of larceny 2nd and conspiracy to commit larceny. Conspiracy to commit larceny 2nd. So I cannot revisit that. And the finding and charge will not be considered. So because the court has already determined probable cause, there's nothing I can decide whether or not it did happen or not happen because there's an assigned arrest warrant, okay? So I just want to make you aware of that. So we really don't have to take much testimony at this time, but I do want you to know about the exhibits that have been filed. So the state filed Exhibit A, the notice of parole violation, Exhibit B, the parole violation report, Exhibit C, the remand to custody, Exhibit D, the parole conditions, Exhibit E, the arrest warrant application by Shelton Police, and Exhibit F, the judicial branch pending case details. So one more time, you did receive that, you said, and you've been able to look over everything?
Yes.
I have not received any evidence from you. We don't have witnesses. So at this time, it would be your opportunity to respond to the parole violation charges against you. However, remember that you do have the right to remain silent if you choose to do so. I have noted what you said about your co-defendant working on stuff. So I will just make note of that at this point, that there's stuff going on in your court proceedings. So are there any additional comments that you would like to make at this time regarding the charge? You have the right to remain silent.
No.
Okay. As stated before, I am making the finding of probable cause on charge number 1, condition of obedience to the law based on the signed warrant from the Superior Court judge. In addition, the state has filed exhibits that support the charge, which is Exhibit B, D, E, and F. And due to that, I do find that the act is serious enough to warrant a revocation, and I've determined that you should remain detained while you wait your revocation hearing. So the records department and your parole officer will be informed. Your revocation hearing will be scheduled upon the disposition of that criminal case, okay?
Okay.
So once that's settled, whatever happens in court, your parole officer will contact us, let us know the outcome of it, and then we'll bring you back in for a revocation, all right?
Okay.
All right, do you have any questions for me right now, Mr. Holman?
No.
All right, good luck, Mr. Holman. I wish you the best and hopefully it all works out, okay?
Okay, thank you.
Thank you. This does conclude the preliminary hearing for Jonathan Holman, ME number 367233.
Yeah.
Okay, come on, Mark.
I just had a full conversation with you muted. I'm so sorry. Good morning, Mr. Gardner. How are you?
Good morning. I'm good.
Good morning.
How are you?
Good. I'm good. I'm gonna go grab your attorney and I have to call your officer to get him on the line and then we'll start, okay?
Yes, ma'am.
Okay, great. Thank you. Yeah. Hello, Sir Davis, are you with us? Officer Davis, are you there?
Yes, I am.
Okay, great. All right, so we are going to start. So I am Parole Officer Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing. I hear noise, but it's him. This is a preliminary hearing concerning Mark Gardner, inmate number 374513. Today is Tuesday, it's Monday, January 27th, 2025. And this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Osborn Correctional Institution. Mr. Gardner, can you please state your full name and DOC inmate number for the record?
Yes, it's Mark Gardner, 374513.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Famiglietti and Parole Officer Davis. Attorney Famiglietti, can you please identify yourself for the record?
Sure. Good morning. Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, everyone.
Officer Davis, can you please identify yourself for the record?
Good morning, Parole Officer Patrick Davis. I work out of the Hartford District Office.
Thank you. This is a preliminary hearing and it has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violates the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe that you violated one or more of the conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Gardner and Officer Davis, please raise your right hands. Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
I do.
Thank you. So we're going to go over the procedure for the hearing. First is I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. We'll then review and identify exhibits filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of this hearing, I'll inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
Me? No. No question, no.
Okay, so we're going to go over the rights you have for this hearing. And the first is you have the right to be represented by an attorney, and counsel's here present for you. You also have the right to receive written notice of the charges of violation. Did you receive that written notice?
That's this document.
Yeah, I believe so.
Yes, I did. Yeah, right? And you were able to review it?
Yeah, pretty much.
Okay. Great. So you also have the right to review the evidence that has been submitted against you for this hearing. You have the right to submit evidence in support of your case. You also have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am. I'm ready to go forward.
Great. So we are now going to review the charges that the state your parole officer is bringing against you and the information underlying each charge. Officer Davis, can you please read the charges and the underlying information?
Yes, I will. Number one, release direction, charge number one, GPS. On 6/7/24, you were placed on GPS at initial intake due to previous noncompliance in the community. At this time, you were instructed on and agreed to properly charging your GPS unit for 2 hours daily. On the following dates, you failed to properly charge your GPS unit as instructed, resulting in your GPS unit shutting down. On 6/10/24, you were allowed your GPS unit to shut down from 7:16 until 7:24 p.m., resulting in 8 minutes of your whereabouts in the community being unknown to this parole officer. On 6/14/24, you allowed your GPS unit to shut down from 3:54 p.m. until the next day, 6/15/24 at 1:45 p.m., resulting in 21 hours and 51 minutes of your whereabouts in the community being unknown to this parole officer. On 6/24/24, you allowed your GPS unit to shut down from 10:38 p.m. until the next day, 6/25/24 at 12:10 a.m., resulting in a 1 hour and 32 minutes of your whereabouts in the community being unknown to this parole officer. On 6/26/24, you allowed your GPS unit to shut down from 11:35 a.m. until 3:40 p.m., resulting in 4 hours and 35 minutes of your whereabouts in the community being unknown to this parole officer. On 7/5/24, you allowed your GPS unit to shut down from 6:53 p.m. until 9:19 p.m., resulting in 2 hours and 26 minutes of your whereabouts in the community being unknown to this parole officer. On 7/7/24, you allowed your GPS unit to shut down from 5:50 p.m. until 6:42 p.m., resulting in 52 minutes of your whereabouts in the community being unknown to this parole officer. On 7/16/24, you allowed your GPS unit to shut down from 6:13 p.m. until 9:55 p.m., resulting in 3 hours and 42 minutes of your whereabouts in the community being unknown to this parole officer. On 7/19/24, you allowed your GPS unit to shut down from 10:07 a.m. until 6:23 p.m., resulting in 8 hours and 37 minutes of your whereabouts in the community being unknown to this parole officer. On 7/20/24, you allowed your GPS unit to shut down from 8:32 a.m. until 8:54 a.m. and from 11:17 p.m. until the next day, 7/21/24 at 1:14 a.m., resulting in 2 hours and 23 minutes of your whereabouts in the community being unknown to this parole officer. On 8/4/24, you allowed your GPS unit to shut down from 11:35 a.m. until 12:31 p.m., resulting in 56 minutes of your whereabouts in the community being unknown to this parole officer. On 10/3/24, you allowed your GPS unit to shut down from 4:14 a.m. until 9:45 p.m., resulting in 17 hours and 31 minutes of your whereabouts in the community being unknown to this parole officer. On 10/19/24, you allowed your GPS unit to shut down from 6:40 a.m. until 6:47 a.m. and from 9:30 p.m. until 9:49 p.m., resulting in 26 minutes of your whereabouts in the community being unknown to this parole officer. On 10/23/24, you allowed your GPS unit to shut down from 1:40 p.m. until 5:36 p.m., resulting in 3 hours and 56 minutes of your whereabouts in the community being unknown to this parole officer. On 12/10/24, you allowed your GPS unit to shut down from 10:42 p.m. until 10:47 p.m., resulting in 5 minutes of your whereabouts in the community being unknown to this parole officer. On 12/17/24, you allowed your GPS unit to shut down from 1:37 a.m. until 8:33 a.m., resulting in 6 hours and 56 minutes of your whereabouts in the community being unknown to this parole officer. This resulted in approximately 94 hours of accountability in the community with location unknown to this PO. On all occasions above, your whereabouts in the community were unknown to this PO, which is a violation of your signed GPS agreement. Number 2, obey all laws. Charge number 2, obedience to the law. On 12/21/24 at approximately 6 p.m., you were arrested by the City of Groton Police Department. On the above date and time, you were seen exiting the parking lot of the Roadway Inn and traveling well above the posted speed limit of 25 miles per hour. The Roadway Inn is an area well known to law enforcement for narcotics trafficking and prostitution. At this time, a traffic stop was conducted. Before the arresting officer exited his cruiser, all 3 occupants in the vehicle, to include yourself, got out of the vehicle and began to walk away. You stated to the arresting officer that since you were already out of the vehicle, the officer was unable to pull you over. You were instructed to get back into the vehicle, but you refused to listen to verbal instructions and commands. During the stop, you continued to yell to responding officers, "You aren't searching my car." Your non-compliance with officers continued throughout the entire stop. Due to your behavior, you were subsequently arrested and charged with 14-215, illegal operation of a motor vehicle under suspension, 14-12A, failure to renew registration, 53A-167A, interfere with officer and resisting, and 12-218A, traveling unreasonably fast. Ultimately, you were issued a misdemeanor summons, MB 823605, with a court date of 1/3/25 at GA10. You were released on a promise to appear. Charge number 3, notification of arrest. On 12/21/24 at approximately 7 p.m., you reached out to this officer that you had police contact. You failed to mention that you actually got arrested and pulled over by Groton Police Department. This PO also gave you an opportunity to tell the truth during a reporting session, and you also failed to do so. This PO had to reach out to the Groton Police Department to get the details of what actually transpired. This is a violation of your signed parole agreement. Number 2, obey all laws. I will notify my parole officer within 48 hours of my arrest for any offense. Would you like me to read the exhibits?
No, because I actually re-identified some of them, so I'll do it. Thank you.
Yep, you're welcome.
So the state did file the following exhibits. I have remarked them for identification purposes. But Exhibit A, the remand to actual custody order. Exhibit B, the statement of understanding the agreement conditions of parole. Exhibit C, the signed GPS agreement form. Exhibit D, the parole violation notice. Exhibit E, the parole violation report. Exhibit F, the police report, misdemeanor summons and complaint. Exhibit G, the offender misconduct. Exhibit H, the decision information summary. And Exhibit I, the Allied Universal reports. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified?
Yes, ma'am.
Okay. So I have not received any exhibits from the defense. Is that accurate?
That's accurate.
Any time to submit any evidence?
No, we do not.
Okay, so then we do not have any witnesses today. So at this time, the state will have an opportunity to make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegation. So Officer Davis, would you like to make a statement regarding the charges?
No, just that the, all the GPS violations speak for themselves. I included them as the evidence, and on 12/21/24, the offender or the subject did get arrested, and the police report's in there as well. Thank you.
Thank you. All right, and counsel, it is now your opportunity to speak to the charges. Would you like to make a statement?
Yes, briefly. Just as a probable cause, I've got no comment as to charges 1 or 2. Clearly, my client did reach out and notified the parole officer of his incident. He did notify him that he didn't have contact, and I would argue that that is sufficient. He may not have even known he was quote unquote arrested. When you get arrested, most people think you get arrested, you're taken into custody and you're brought to the police department. He's nodding in the affirmative. That is the standard commonplace understanding of what an arrest is. If you look up the Black Law Dictionary, it's basically a removal of your liberty is an arrest. That was not done. And this is not a case where he didn't inform his PO at all. At 7 p.m. that evening, which was not long after the incident, he did notify his parole officer of the police contact. That's the reason why the parole officer was able to go and check with the police department. So I don't believe there's probable cause for charge. As to the seriousness of the allegations, he was given a promise to appear for this misdemeanor summons. Telling the police when they ask you, can we search your car? No, you cannot search my car, is exercising your constitutional right. It is not resisting arrest. So I don't believe that resisting arrest charge is serious, and I certainly don't think the elements are going to be made in court. It's essentially a misdemeanor summons for a motor vehicle incident. And then it appears as though for a long period of time, almost the whole time before his arrest, or his remand, excuse me, the whole time before the remand, which technically because he was taken into custody as an arrest, the whole time he was basically delinquent with his battery going on and off. I don't think that's necessary. This is not as though he absconded. This is not a situation where he was committing crimes during that period of time. This is a situation where he was, if the allegations are true, not charging his battery to the best of his ability. I don't think that's a reason or serious enough to incarcerate someone. This is his first violation. Thank you very much for your time and consideration.
Thank you. Just gonna take a moment and I'll let you know my findings.
Can I say anything?
I wouldn't, sir.
Okay.
Unless you have something to add that I didn't say.
No, sir.
Okay, thank you. You don't mean to be rude, but anything you say can be used against you as an admission of the conduct or anything that happened. So I don't want you to give testimony against yourself, okay?
Right.
If it was something I didn't say, that's a different story.
Yeah, the GPS shutdowns was I was at work. And
okay.
I have pay stubs and everything that Officer Davis has to prove I was at work, and he knows my work. I'm a tow truck driver's assistant. So it was like difficult to charge the bracelet and be, you know.
Who do you work for?
I work for my family owned business. It's Gardner Auto Body. It's in
And
East
what are your hours?
My hours, it range from really like on call. Officer Davis knows already. I usually work from like 8 in the morning to like 6 at night. But when a call would come in for a tow or a pickup or anything like that, I would usually go with.
Okay, and is there a way for you to charge your battery in the truck?
They gave me like just about like a couple of weeks before I came in they gave me a car charger for my battery, and I started doing that exponentially good.
Okay, so it improved when you had the car charger, and they gave you a car charger. You have no access to buying a car charger, right?
No, sir.
You can't buy a car charger that's going to work with that device, correct?
Right, sir. I can't.
It was a specific car charger that you were given by Parole.
Yes, yes, sir.
Okay, all right. So they obviously knew that's what was going on. It appears as though, for at least some of it. Okay, thank you. And even because of that now, even for more reason, I don't believe that the violation is sufficiently serious enough to require a revocation hearing and further incarceration. Thank you.
Just 1 moment. Okay, so for charge number 1, condition of GPS, I identified this charge as 50 separate parts. For part number 3, associated with the date of June 24th. Did I do that right? Okay, number 3, does that sound good to you,
yes,
Attorney? June 24th, 2024, I am making a no finding of probable cause, as I do not believe the state submitted sufficient evidence in support of the charge. However, for parts number 1, 2, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, and 15, I am making a finding of probable cause based on the evidence submitted by states exhibits B, C, E, G, and I. For charge number 2, condition of obedience to the law, I'm also making a finding of probable cause based on states exhibits B, E, and F. And on charge number 3, condition of notification of arrest, I'm making a no finding of probable cause as the state failed to submit sufficient evidence in support of the charge. And I do not believe the elements were met. So that does conclude the fact-finding portion. I am finding that the act is also serious enough to warrant revocation. So I've determined that you should be detained while you wait for your revocation hearing, which will be scheduled upon the disposition of your criminal charges. The records at the facility you're at will be notified of this, and Officer Davis is now aware of it as well, okay? So once those charges are disposed, we'll schedule you for a revocation hearing once we receive the information from Officer Davis, okay?
Can I just briefly say something to my client? He doesn't know.
Sure.
So, sir, because you were given a PTA and a summons, okay? Court did not know in London that you're incarcerated. So I called the courthouse and spoke with the clerk. So they will be getting you in for your court date. So they're not going to just sit in jail. I let them know you were in jail, even though there was a PTA. And when you get there, I also notified the public defender's office, apply for a public defender, okay?
Yes, sir. Appreciate it.
You're welcome. You're welcome. Good luck, sir.
This does conclude the preliminary hearing for Mark Gardner, inmate for 374513. I'm sorry, I cut you off. Are you okay? You're good, Mr. Gardner?
Yes, I appreciate all 3 of you guys. And what's up, Officer Davis?
All right, take care, Mr. Gardner. Good luck.
Too.
Have a great time.
You too.
They're waiting for you after that. You might can just go straight that way. And I'm just waiting for Lozada to get here. Thank you.
Perfect. Thank you.
You're welcome. Yeah, see, right?
There we go. All right, I thought it messed up my recording. Good afternoon, Mr. Lozado. How are you? Lozado, I'm sorry.
Trying to feel better. I caught the flu.
Oh, I'm so sorry. Is it going around up there? You guys all seem kind of off.
The whole jail.
Yeah, I believe it. Well, hopefully it'll feel better soon. So I am Parole Officer Tricello, and I'm the hearing examiner at the Board of Pardons and Paroles. And this is a preliminary hearing concerning Angel Lozada, inmate number 428584. Today is Monday, January 27th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Osborn Correctional Institution. Can you please state your full name and DOC inmate number for the record?
My name is Angel Lozada, 428584.
Thank you. This is a public hearing and public access to this hearing is available via video live stream. Present this afternoon is Attorney Dean. Attorney Dean, can you please identify yourself for the record?
Yes, Anna Dean on behalf of Mr. Lozada. Good morning, sir.
Good morning.
So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there is probable cause to believe you committed an act that violates the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Lozada, can you please raise your right hand? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
Thank you. So we're going to go over the procedure for the hearing. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. I'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have the opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I'll inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Okay, great. So you do have some rights for this hearing, and the first right is the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yeah.
You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
Great. So we're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. Okay, so bear with me, it's quite a bit. All right, so on charge number 1, condition of GPS, the charging officer reported that on 12/20/2024 at approximately 1:47 p.m., this PO received a one-piece GPS HE1 strap email notification from Allied Universal indicating that you had removed your GPS from your ankle. Upon review of the video surveillance footage from the Watkins halfway house, you were observed at that time in the driveway outside of the halfway house, removing the device from your ankle and throwing it towards the street before running away from the halfway house. The halfway house staff was able to retrieve the device from the sidewalk. This is in violation of your signed GPS agreement. Charge number 2, condition of halfway house placement. The charging officer reported that on November 25th, 2024, you signed out of the Watkinson halfway house at 11:50 a.m. to attend a shopping pass with a return time of 4:30 p.m. You failed to return to the halfway house until 6:35 p.m. and you did not make any effort to contact the halfway house staff to state that you would be late. Furthermore, you returned without the money you signed out with or receipt for spending. This is in violation of your signed halfway house agreement. On 12/4/2024, you signed out of the Watkinson halfway house at 11:27 a.m. for a dental appointment with a return time of 2 p.m. You failed to return to the halfway house at your scheduled return time. Staff contacted the dental clinic and were informed that you did not have an appointment on that day. Staff made contact with you at 3 p.m., to which you stated that you were on your way back. You never returned to the halfway house and did not make further contact with the halfway house staff. The PO attempted to contact you with no response. Your whereabouts in the community were unknown until this PO made contact with you via phone at 8:45 a.m. on 12/5/2024. Instructed you to return to the halfway house. You returned back at approximately 10:30 a.m. on 12/5/2024, and therefore you were unaccounted for in the community for 23 hours. This is in violation of your signed halfway house agreement. On 12/16/2024, you sat out of the Watkinson halfway house at 11:01 a.m. to attend an intake appointment at community renewal team in Hartford with return time of 2:30 p.m. This PO was informed via email by CRT staff at 1:06 p.m. that you did not attend your scheduled appointment, returned to the halfway house at 1:45 p.m. and informed this PO that you chose to spend time with your family instead of attending your appointment. This violates your signed halfway house agreement. Specifically, that will only go to location indicated on the approved community pass. On 12/20/2024 at approximately 1:47 p.m., this PO received a notification via email from Allied Universal that you had removed your GPS unit from your ankle. This PO contacted the Watkinson halfway house staff shortly thereafter, instructing them to conduct an emergency count. Staff conducted an emergency count, could not locate you anywhere in the building or on the property. This PO attempted to contact your cell phone with no response. Halfway house staff reviewed video surveillance and observed you exiting the building through the side door without authorization, walking down a driveway and removing your GPS unit prior to running down the street away from the halfway house. This PO continued to make attempts to contact your cell phone with no response. This PO made contact with your girlfriend and godmother, who denied knowing your whereabouts. Local hospitals and police departments were contacted with negative findings. You never returned to the halfway house or made contact with this PO. Your whereabouts in the community were unknown until 1/7/2025 when you were located by Parole staff at your girlfriend's residence in New Britain and taken into custody of Parole staff. In charge number 3, condition of mental health evaluation and treatment. The charging officer reported that on 12/16/2024, you signed out of the Watkinson halfway house at 11:01 a.m. to attend an intake appointment at community renewal team in Hartford with a return time of 2:30 p.m. This PO was informed via email by CRT staff that at 1:06 p.m. that you did not attend your scheduled appointment. Upon this PO's reviewing your GPS points, you did not report to CRT on Market Street in Hartford and instead appeared to be at a residence on Zion Street in Hartford. This is in violation of the condition of mental health evaluation. The state has filed the following exhibits. What did I do? I had to remark them. That have been remarked for identification purposes. So I have Exhibit A, a notice of parole violation. Exhibit B, a notice of parolee rights. Exhibit C, a remand to actual custody order. Exhibit D, PCS signed conditions. Exhibit E, halfway house agreement. Exhibit F, residential discipline report. Exhibit G, offender misconduct. Exhibit H, a parole violation report. Exhibit I, a residential incident report. Exhibit J, offender misconduct. Exhibit K, GPS monitoring agreement. Exhibit L, the Allied Universal Position History from 12/16/2024. Exhibit M, the residential incident report. Exhibit N, the offender misconduct, unsigned. Exhibit O, the email correspondence from community renewal team. Exhibit P, an offender misconduct, unsigned. Exhibit Q, Allied Universal event history from 12/20/2024. Exhibit R, the Allied Universal Position history from 12/20/2024. Exhibit S, the residential incident report, and Exhibit T, video clip from Watkinson house, halfway house surveillance camera from 12/20/2024. Council, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents?
Yes, I have.
Perfect. I have not received any exhibits from the defense. Is that accurate?
Yes, if this does go to a revocation hearing, we would submit some exhibits.
Okay, thank you. So at this time, we do not have any witnesses, so it is the defense's opportunity to respond and make a short statement, call me witnesses, and testify with respect to probable cause.
Yes, thank you. I just have some brief comments. As to the second charge, there's just a couple things I want to note. First, the narrative for that charge indicates that my client's whereabouts in the community were unknown from that 12/20/2024 date forward. However, based on speaking with my client, we believe that Parole did know where he was the entire time. When he was remanded, he indicates that he spoke with his parole officer who told him look, we knew you were here. We wanted to get you through the holidays, give you an opportunity to be with your family prior to remanding him. So I would just argue that they did know his whereabouts. Second, I do just think it's worth noting, this is my client's, I believe, first time home since suffering a very devastating loss. He did unfortunately lose his mother while he was incarcerated, and that is a situation that he is still grieving to this day. So he is somebody who is wanting to do better in the community. This isn't a situation where he picked up new charges. He's been doing well. He did get any new cases. He was not charged with absconding in this situation either. I also think it's additionally worth noting that he has a very large network of support in the community at this point. I believe he was lacking before. That includes his girlfriend, Miss Paul, and other family members, including Mr. Rodriguez, who want the best for him. They want to challenge him to do better. If released back into the community, I do believe he now has a support system that will hold him accountable and help him succeed in what he hopes to do. So I would ask that if a finding is made, that he be considered to, handle this in the community rather than in incarceration.
Thank you. I'm just gonna take a moment and let you know my findings. So I am going to make a finding of probable cause for charge number 1, condition of GPS, based on the evidence presented in the state's exhibits D, H, K, Q, and T. For charge number 2, condition of halfway house placement, I've identified it as 4 separate parts and I'm making a partial finding. So for part 1, dated 11/25/2024, and part 3, dated 12/16/2024, and part 4, dated 12/20/2024, I'm making a finding of probable cause based on the evidence presented in state's exhibits D, H, E, F, G, M, O, Q, and S. For part number 2, dated December 4th, 2024, I'm making a no finding as the state failed to submit sufficient evidence in support of the charge, and therefore I do not believe the elements were met. And for charge number 3, condition of mental health evaluation and treatment as deemed necessary, I am making a finding of probable cause based on evidence presented in support of the charge, which is states exhibits D, H, and O. In addition, I am finding acts are serious enough to warrant revocation, and I've determined that you should be detained while you await your revocation hearing. So the records and in the facility here will be notified of this, as well as your parole officer, and your revocation hearing will be scheduled within 60 business days of your remand. Mr. Lozada, do you have any questions?
No, I don't.
So if you want to call my office, Mr. Lozada, you can. We're going to get a secondary hearing, a revocation hearing that has a higher standard of proof where we'll submit additional evidence. My social worker will also reach out to you prior to that hearing, and I will contact your 2 family members as well to get info from them, okay?
All right.
Thank you very much.
This concludes the preliminary hearing for Mr. Lozada.
Thank you too.
428-584. All right, good luck, Mr. Lozada. Feel better.
You too, mistaken.
Thanks.
Yeah.